here for the Waikaka Gold Mines Limited application for a suite of resource consents from Environment Southland and Gore District Council. So I hope you're all in the right place for that. Before any introductions, just like to call whether anyone in the room would like to deliver a karakia. And if not, Commissioner Dykstra has agreed to do that.
Well, kia ora koutou. The karakia that I'm going to open us with today will ensure that our conversations are fruitful and that there's a good depth of knowledge provided today. So, me noi tātou. Kia tau ngā manaakitanga te mea naro, ki runga, ki tēnā o tātou, kia mahia, ngā hua, ma kihiki, kia toi te kupu, toi te mana, toi te aroha, kia tūturu, ka whakamaua, kia tīna, hui e tae kia. And we also want to acknowledge the original name of the Waikaka River today, the Waikakahi. But for the purposes of clarity, we will use the current mapped name of Waikaka Stream.
Thank you, Commissioner. So by way of introduction then, my name is Ian Boothroyd. I'm an accredited independent resource management commissioner with a chair endorsement.
Tēnā koutou anō, ko e au, ko takatimu te maunga, ko aparima te awa, ko kaitahu me te kati māmoe o ku iwi, ko oraka aparima me awarua toku rinaka, ko Stephanie Dykstra toku ingoa. Kia ora, my name is Stephanie Dykstra. I'm also accredited independent hearing commissioner, and my whakapapa does sit within the Murihiku region at Oraka and Awarua, but for clarity's sake, I am not a member of Hokonui Runaka. Kia ora.
Thank you.
Morena koutou, my name is Rosday Cleven. I'm a resource management practitioner who is accredited as an independent commissioner. I live in Otapoti, Dunedin. It's good to be here, thank you.
Thank you. And our hearing commissioner, Catherine Onko, if you'd like to introduce yourself and give a health and safety briefing.
My name is Catherine. I'm a consent coordinator from Environment Scotland. I'm here to coordinate a hearing today at Gore District Council for the Waikaka Gold Mine Limited. For the health and safety of this room, in case of fire emergency, please follow the council staff out that door, and they will bring you to the assembly point, which is outside of the right to the building. The toilets are going out right of this room, and then turn right again when you come from the building. Other than that, I think we are all good to go.
Thank you. Just a reminder, everybody, mobile phones off, I think, is the other thing as well.
Could I just quickly raise, I understand Mr. Webber has got no sound.
Can others online hear us? Thank you for bringing that to our attention. Yes. And we might need to get Matthew back in. Apologies for this. Yes, yes. We'll see how we get on. Just testing. Is that any better, Mr. Webber? It would seem not, no. We might need to get the IT,
Yep.
Mr. Matthew, back in to help us. Are you okay, Ms. Davis, if we carry on? It's just a round of introductions, yes, and starting with yourself back, so perhaps we'll just go around the room. Yes.
That's good segue. My name's Asha Davidson. I'm a barrister representing the applicant. I'll let the witnesses introduce themselves. In addition, online we have Mr. Webber. Mr. Espy will be joining us later.
Is that everyone's understanding?
Yes, that's my understanding, and Mr. Dundee will be here for that. I've also asked Mr Espy, or told Mr Espy doesn't need the 2 hours. He can speak pretty quickly before lunch.
Yes, thank you. That's right. We don't actually have many questions from Mr Espy, but we do have one or two. I'm just checking you're okay with that. Well, it's often referred to as a hot tub. I don't think it'll be that hot, but we will be together. So I think that would be an efficient way to deal with it if you're happy with that.
Yes.
And the same with the council. Yes, thank you, thank you. That's, and I'll explain some of the, I should add that for each of those witnesses, and I'll explain it at the time, they're all welcome to present their summaries individually, and we may have some separate questions for them individually on their evidence, but more broadly we'll open it up to a discussion that will be directed from the chair, of course, where each will get a chance to respond to the questions we put to them. So thank you for that. I'll just acknowledge we had our site visit yesterday. Very fortunately, the weather turned out to be quite glorious for us just over that particular valley, so we had a good look around, and we got to visit the river, the Waikaka stream, 2 or 3 locations and walk a little bit along the banks, which was very helpful. We got to the confluence with Shepherd's Creek. We saw the ponds and the ditch, the N&M pond, and the general lay of the land. So thank you for organising that itinerary. It worked very well for us. And it was good to be out there, I think, independently. So I think that worked well for everybody as well. So a couple of things procedurally, Ms Davidson in particular. When it comes to the right of reply at the end of the hearing, you're very welcome to deliver that, but we're quite happy to receive that in writing at some later date, preferring to have a much more reasoned reply than anything hurried. We'll organise what the timing might that look like at that moment. And then I think it's worth signalling right at the beginning that with regard to the timing, the panel, all 3 of us have quite a busy schedule through to the Christmas break and even beyond into the new year. So I think it's worth managing expectations as to what the timing might look like for us as to whether and depending what might be required at the end of the hearing in terms of any homework that might be applied, whether the hearing may or may not close even before Christmas, and it may be after that RMA days before we get to that. I hope that's not too disappointing, but it's better that we have the opportunity and the time to do a reasoned deliberation than anything hurried, given that state of busyness that we find ourselves in. I hope you're okay with that. Thank you. Just signalling that now, and same with the council for everybody there. Are there any other matters that need to be raised at this point? Ms Davidson, I think, just in time, look, just in the nick of time. I'm just going to say we haven't received your submissions. Our preference actually has been that the witnesses, perhaps less for yourself, do move to the table at the end and sit directly in front of us. Yes, that's right, rather than having to look sideways for the whole day. So when that comes, I'll direct people accordingly. So thank you for that.
I'm happy to move over there if you want to start saving your necks. Maybe that.
Perhaps, if that's okay with you, maybe, yes.
I might have a bit more space.
Yes, well, that might work as well. And we've got to have the papers delivered anyway, so we'll just give ourselves a moment for that. Thank you. Thank you.
I understand is on the verge of being signed, but is not quite there yet. So I think there's one outstanding signature, but that should be available for distribution shortly. So in my submission, the only real remaining issue relates to freshwater ecological effects of the proposal and the effectiveness of the mitigation proposed. It's on that issue and its implication for the required assessment under the RMA that these submissions will focus. I also note that at the time of the Section 42A reports, Hokanui Runanga's submission was still stated to be in opposition and the cultural impact assessment had not been provided. That has obviously now changed and Hokanui Runanga have confirmed their comfort with the conditions that the applicant has put forward and has amended its position. I anticipate that the officers will update those aspects of their reports. I've just noted here, I haven't gone through an outline of the mine proposal, which I would sometimes do in submissions because it's been very well traversed in the various documents, and I know that you've read those in advance, but if the commissioners would be helped by that at this stage, I can ask Mr. Batt to sort of talk you through the mine proposal. Would you like him to do that, or otherwise he's next up and can talk to you then?
I don't think we need to go through it completely, but I do have some questions just some aspects of it, or maybe we'll do it that way. Oh, sorry, yes, I'm going to do this all day, aren't I? Sorry, I'll repeat that. I don't think we need to go through it in its fullness. I think we agree with that, we're happy with that, but we might have some questions over particular aspects. So we'll come to that at the time.
Okay.
So thank you.
We'll address that when Mr. Batt gives this evidence. Thank you. So from paragraph 12, I've outlined what I understand to be the outstanding issues, which I've separated into the stream and the creek, the ditches and the ponds. I think they are quite distinguishable. The first, for the stream and the creek, is whether the diversions will provide appropriate habitat for freshwater species on a temporary basis while the diversions are in place, and then whether the rehabilitation of the stream following the diversion will successfully remedy any relevant effects. For the ditches, my understanding is the issue is whether there's confidence that appropriate habitat will be provided for the displaced golem galaxids. And for the pond, whether a replacement pond is to be formed and will provide appropriate habitat for species currently occupying the ponds. The case for the applicant is that the conditions it proposes, or as might be amended in light of the evidence, provide the commissioners with sufficient confidence that all of those matters can be answered in the affirmative, such that consent can and should be granted. The outstanding issues are relevant both to the assessment of effects on the environment and the assessment of the proposal against relevant objectives and policies, and obviously in this case they are very intertwined. For these purposes, the key provisions of the statutory planning documents are the National Policy Statement on Freshwater Management. I've particularly noted policies 7, 9 and 10. The Southland Regional Policy Statement, which is there twice. The Bio 4 and Bio 9 policies, and the proposed Southland Water and Land Plan, Policy 28 and Policy 32. For convenience, I have set those out in an appendix because I suspect, if not in my submissions, then other witnesses may refer to those, so it may be handy to have those in one place. To assist the commissioners in assessing the evidence on these matters, my submissions will address the effects of the proposal and the proposed approach to addressing them, which is relevant under 1041A. The approach to assessment of the proposal against the relevant statutory instruments, and that's with particular consideration to Policy 28A, provide for monitoring, which will provide early detection if the rehabilitation outcomes are not on track to being achieved. If that occurs, additional rehabilitation measures such as supplementary planting, additional habitat enhancement, erosion protection, fish passage or in-stream cover improvements are required to be implemented in the following year, and that's provided for in the applicant's proposed condition 39. If rehabilitation to at least as good or better standard has not been achieved after 3 years, a remedial plan must be implemented and monitoring continues until the outcome is met. Fifthly, ES retains its ability to review the consent under Section 128 RMA if the conditions prove inadequate to deal with the effects. And to that I might add that conditions are intended to be in place and enforceable, and of course we do have very strong enforcement regime in place, and I understand that is intended to be strengthened if anything. It's also relevant that Hokanui Runanga has endorsed the applicant's proposed conditions and will have continued involvement in the design, implementation and monitoring of the rehabilitation scheme. Their active involvement provides an additional layer of local knowledge and expertise to ensure appropriate outcomes are achieved as quickly as possible. In my submission, this is not a case where the mitigation is highly speculative or where there is a reasonable expectation that, despite conditions, the rehabilitation might completely fail. As noted, Mr Dungy remains confident that rehabilitation will effectively be fully achieved within 5 years. In the worst case scenario where that expectation is not realised, it might take slightly longer. Direct experience in this particular environment tells us that good quality habitat will evolve naturally. The measures proposed to assist in bringing that result sooner and to a better quality. Now, I've just noted that while the applicant has proposed conditions it considers will meet and provide confidence in the intended outcomes, it's acknowledged there's room for enhancement of these to provide additional clarity and certainty, and that's certainly been a topic of discussion, as I understand it, in the conference room. So turning to the temporary effects that arise before the rehabilitation proposal takes full effect, it's acknowledged there will inevitably be some effects on the availability and quality of habitat on a short-term basis. The applicant has sought to address those by a range of methods, including minimising and mitigating the interim effects by providing for diversion channels and techniques within those channels to seek to provide suitable habitat on an interim basis. It proposes staging the stream diversions and ensuring that fish passage is available throughout, and it proposes relocating fish in an affected waterway to an alternative suitable habitat. In my submission, it's important to apply perspective when assessing temporary effects. The time frame over which effects will occur is relevant, and a temporary adverse effect is different in type and scale from a permanent one. That temporary adverse effects might be found acceptable when considering the grant of consent was expressly acknowledged by the High Court in Chilane, which differentiated the relevance of temporary effects when considering notification versus a substantive assessment. I might just pause to let you read the extract from that decision there, but the underlined or the emphasised part of that citation is that the assessment of temporary effects may, of course, be they may be held to be appropriate in deciding whether to grant the resource consent. Concerned the proposed Auckland Regional landfill, which would result in the permanent and irreversible loss of 12.2 kilometres of permanent and intermittent stream habitat, which would impact a range of at-risk declining, at-risk naturally uncommon and possibly threatened nationally vulnerable freshwater fauna. It was acknowledged that while fish salvage and relocation was proposed, there would be residual adverse effects from injury and mortality of macroinvertebrates that could not be mitigated or remedied, and those were proposed to be managed through offsets. There were a range of other effects associated with the landfill, including loss of and effects of natural inland wetlands, effects on indigenous fauna such as long-tailed bats, which meant a wider range of MPS and unitary plan policies were in play. I mention that just because those aren't in play in our case, but if you're reading the High Court decision, obviously there's a wider range of policy influences which affect the decision, but there is helpfully a particular discussion of the rivers policy. So in that case, the Environment Court had issued an interim decision indicating consent could be forthcoming, subject to improved design and more certain conditions and management plans. A key issue for the Environment Court and the High Court on appeal was how the proposal, which I note was also a non-complying activity, should be assessed against the relevant provisions of the MPSFM and the unitary plan, which included the mandatory provisions directed to be included. In the same way as the proposed Southland Water and Land Plan includes Policy 28, as I say, the Auckland Unitary Plan included the identical wording, and I refer to that as the Rivers Policy. The appellants in that case argued, among other things, that the Environment Court had failed to apply the avoid requirement of the Rivers policy by applying a material harm analysis which allowed effects to be minimised, remedied, offset or compensated rather than simply avoided. And the High Court agreed that the Rivers policy was an avoid policy which created a bottom line. And that meant that if the proposal had been found to be contrary to the policy, an exceptions pathway analysis would have been required of the type applied in East-West Link. I haven't gone into that exceptions pathway here because I don't think it's applicable. We get through the other, we don't get there, I should say. However, the Environment Court had held that the proposal would not be contrary to the objectives and policies of the Unitary Plan, including the Rivers policy, provided it was satisfied that overall there would be no material harm from the removal of streams. The assessment was to be undertaken taking into account all aspects of the proposed mitigation, offsets and residual effects. The Environment Court had held the short point is we've already identified that we must be satisfied that the application avoids material harm from the adverse effects of discharges and the removal and reclamation of a stream or streams. And further on, if we conclude substantively that material harm is avoided, then the application will not be contrary to that key policy thrust. So the test of material harm was applied in RMA context by the Supreme Court in Port Otago, following the approach it had applied in Trans-Tasman in the context of the Economic Zone and Continental Shelf Environmental Effects Act, as follows, and I will just read that. This is the Supreme Court in Port Otago. This court in Trans-Tasman said that the standard was protection from material harm, albeit recognising that temporary harm can be material, and I'll return to that point. Although in a different context, the comments were nonetheless applicable to the New Zealand Coastal Policy Statement. It is clear from Trans-Tasman that the concepts of mitigation and remedy may serve to meet the avoid standard by ceased, but also the total duration of the projected harm before remediation will occur. The longer the period before remediation occurs, the longer there will have been harm to the environment. That in itself may mean that the bottom line of protection is not achieved. In other words, what is a reasonable time for remediation must be assessed in a manner that is consistent with the Section 10.1b bottom line of protection of the environment from material harm. So in that case, the Supreme Court held that temporary adverse effects do not necessarily mean that there will be material harm in contravention of an avoid policy, provided they are remedied within a reasonable time. And what constitutes a reasonable time and whether residual effects meet the standard of amounting to material harm is a question of fact. I've just noted a similar observation was made by the Environment Court in the Royal Forest and Bird decision, that we consider that, as with all of these policies, and that included the NPSFM, a long-term approach must be taken to a consideration of effects. The assessment must account for all aspects of the design and undertaking of the proposal, including all measures to mitigate the adverse effects of the proposal. This necessarily includes rehabilitation of the mine site. This reinforces my earlier point in relation to the relevance of temporary effects, which naturally flows into the consideration of policies and objectives. The focus is on what the statutory documents are seeking to achieve, which is to ensure appropriate environmental outcomes at a national, regional and ecological district level, not a zero effects outcome at any particular point in time. So,
may I just pause there a
yes.
moment, just for clarification for my purposes. Temporary, using that term, is this referring only to the temporary diversions or also to what we understand is a possible time lag between the rehabilitation starting and it achieving a suitable endpoint? Are you seeing that all in that temporary perspective?
I was thinking about it in terms of diversions, but I think you're right, you have to look at it to the end point and what effects arise essentially from the start of mining to the point at which it's completely rehabilitated to as good or better. Of course, that will be a hopefully sliding scale downwards to the point where the last couple of years might be very low effects, starting with a higher one. But the emphasis being on we are trying to keep that level of effects down as far as possible by the features which are included both in the diversions and in the rehabilitated stream corridor. So yes, I think we are, as for Trans-Tasman, looking at the period from start to finish of
start to full rehabilitation.
When remediate, because we are relying on remedying the effects in this case. So that is the relevant period within which you would look.
Thank you. I think that's helpful clarifying that.
I've spent quite a bit of time on this because I understand the case, particularly for the Department of Conservation, is that because there are temporary effects in that time, that triggers a need to offset. That's not how I understand this policy working or the case law working. So I have laboured that possibly a bit, but I'm hoping that it will give you the information you need to assess that submission at the time.
Well, the reason I raised that is, the term temporary versus the residual is quite material to decision making. So I just wanted to be able to clarify that. And perhaps as you go on, I see you do address this particular proposal, and maybe during that just be clear to us on which components we're on, or someone else may as time goes on through the hearing. Yes.
I would say the case for the applicant is that it is intended that there be no residual effects, because we are looking at it, and the court accepted that the test is whether the project, being the specific infrastructure itself, meets the functional need test. In that case, the project was a state highway. In this case, it's a gold mine. The appellants in that case had argued that there was no functional need for that road because works could be done on the existing road to bring it up to meet the same project outcomes, and the court considered that wasn't the right test. The court also emphasised that the focus of the definition of functional need is not on a particular location, but the need for it in a particular environment. And it said there that the environment's much broader concept than a location. So I think that probably answers the question to some extent, is that it's the environment, not the particular. I mean, I think it's also maybe helpful for you to hear from Mr. Batt the extent to which the applicant has gone to identify where the resource is, and in fact the measures that have been taken to minimise the environmental effects, which has actually foregone the opportunity to win a significantly more valuable part of that resource. So in my submission that comes into the avoid category once we get to the effects management hierarchy. The CJ Industries decision, which I referred to above, the Environment Court applied that Putama Kaitiaki decision in relation to highly productive land, and that requires that an activity have a functional operational need. I believe that was in relation to a quarry. And the court accepted there that there was both a functional and an operational need for the proposed activity to occur, as that's where the aggregate is located. So I've said in this case the gold resource is located in and around the stream environment. The project is a gold mine with its core function being the extraction of that gold resource. In my submission there's a clearly functional need for the mine to be located in this particular environment, and I don't understand that to be disputed. So does that answer your question, or?
It certainly does. Thank you. Okay, it was very helpful.
So turning to the effects management hierarchy, I've set that out here, but I won't take you through it. The commissioners will be familiar with that hierarchy. In my submission, the applicant's approach to this project from this application, right from the very design of the project, has been one that epitomises what's intended by this hierarchy. It's been aimed at avoiding the loss of river extent and value to the extent practicable. And Mr. Batt's evidence explains how the original proposal for the mine involved a permanent diversion of the Waikaka stream, but that was abandoned following consultation with Hokanui Runanga, dock, fish and game, and as a result the project was significantly reduced in scale in a way that avoided the permanent diversion, but as I say also reduced the expected take by around 8,000 ounces of gold. And Mr. Batt notes that that represents a loss of more than $50 million. The point for present purposes, though, is that the adverse effects on the stream were avoided through choices by the applicant as to the scale of the proposal and the methods to be employed. So my submission that is relevant to that first limb of the hierarchy. So in addition to avoiding loss of river extent and values to the extent practicable, other steps in the hierarchy seeking to manage the loss of river extent and value include providing for diversions of the stream such that habitat will remain available and fish passage will never be impeded, and through a range of other measures secured through conditions to minimise the impact of the work on aquatic fauna. And that joint witness statement may not have been as helpful as it was, but at the very least it got the ecologists in the same room, so I'm sure they'll be well positioned to answer your questions today. Finally, in conclusion, the applicant wishes to acknowledge the positive and constructive manner in which the councils and the submitters, including Hokonui Runanga, have participated in this process to date. This has led to a situation where almost all issues are agreed as between the parties and the outstanding issues are well articulated. I've listed there the witnesses that will be called for the applicant. I don't think I need to go through all of those. As was indicated in Directive 1, I have told the witnesses that I will call them, get them to confirm their expertise and qualifications, any corrections to the evidence, and to confirm, and then to be available to take questions. Some of the witnesses, the more technical witnesses, have prepared short summary statements which they can take you through, and Mr. Webber has a brief PowerPoint which serves as his summary, which he will speak to briefly. That is everything. The commissioners have excused Mr. Hegley. He thanks you for that direction. Obviously, if there are any questions arising, we can get him to respond. I've noted that we anticipate, and this leads into the Chair's comments at the start of the hearing, that a revised set of conditions will be required. We haven't prepared that yet because it's a bit of a moving feast, but we do anticipate that a revised set of conditions reflecting the outcome of expert conferencing and amended in light of any evidence through this hearing can be provided by way of reply. There may need to be some further planning conferencing on that, but perhaps we'll just see how things evolve. And finally, should there be any other issues that arise during the hearing, I'm obviously happy to address you on them as we go and reply.
Thank you, Ms Davidson. I think we'll continue with any questions before we take a break.
Yeah, sure.
If we may. Just on that question of the consent conditions, seeing as we haven't received the ones that from the planning conferencing of yesterday, what set should we rely on for the beginning of this period of the hearing at least?
For now, I would rely on the Appendix 1 of Ms Colley's evidence.
Thank you.
Sorry? Appendix 2,
Appendix
apologies.
2.
Yes.
That would be my suggestion.
Yes.
Thank you.
I don't understand that the planning conferencing had time to get into particular wording of conditions. At that point, I think there was still one or two joint witness statements that were yet to be signed off. So, yeah, unfortunately that is not as evolved as it could have been, but that's certainly the intention, that they will continue to work on particular wording.
Sure. And when might we expect that an updated version? I mean, well, we can come to. We've got a decision of what we're going to work on for now.
Yes.
But obviously there are some recommendations that have been coming through since that Appendix 2 version.
Yes.
We just want to make sure that we have, one source of truth for the
Yes.
conditions.
Yeah, I think as well, the joint witness statements have tended to outline what they would like to see in the conditions as opposed to specific wording. So
Yes.
there will be a bit of interpretation that the planners need to do to make sure that that's properly reflected in the conditions. So that is clearly directed to the loss of river extent and values, and that the ditches and the ponds don't qualify as river. That's the short answer. We probably didn't need to go there, but I don't think that there is any dispute about the fact that the man-made ditches and the mining ponds are rivers for the purposes of that policy.
Thank you.
Actually, just following through on that, I mean, I've assumed, although I didn't see it written, that means that they meet or don't meet the definition of rivers in the RMA and therefore as an artificial watercourse.
Yeah,
I think
that's my understanding.
Yes, I think so, yes. Just clarifying that, because
Yes.
whilst ditches, etc., were used, it was never kind of clearly specified.
Yes.
As where I could see that, but we all understand that. I have a question which is related to something that was not in your submissions. And this is related to what I understand is an outstanding application for an access agreement with the Department of Conservation. We don't necessarily need to know the status of that, but if we do, that's helpful. My question, though, is the status of that, or the fact it's not resolved, does that limit us in any way in making a decision on this application that you put before us?
The short answer to that is no.
Thank you.
There are separate statutory or RMA versus property law, Department of Conservation issues. They're obviously both need to be in place in order
Yes.
for the project to be implemented, but it's not a requirement that the access be sorted before the resource consent's issued.
Thank you, that's just helpful. Just confirming that.
Okay.
Any other questions or clarifications? Okay, thank you, Ms Davidson. Thank you for that very much. We'll take a short break now.
Yes.
Actually, we're running a little bit behind the timetable schedule.
Sorry about that. Thank
No,
you.
that's okay. No, that was very helpful. And Mr Batt will be up, but we'll take, what's the time now? My glasses on to see. It's, well, just after 20 past. If we come back at 25 to, is that okay? 10:35?
10:35. Thank you.
Thank you, yes. Has it come through, is it? Okay, all right. Well, hopefully we can get them printed, yes.
Well, no, he's just going to, he's just really going to talk about the presentation and then I'll a few questions.
Yeah, no, I don't quite know how he missed.
That's
There are a few other devices and you could actually get a decent
there's quite a bit of outlining and things going on. It's kind of like, well, because you actually have something that's, because there is view structure there. It's right. I mean, yeah, exactly. Well, that's which is, well, that's right. Which doesn't. I mean, yeah. Yeah, well, that will then because he's.
is crucial to the viability of the project. We actually have looked at the project, mining it without diverting the stream at all, crossing to one side, but it sterilises too much of the resource. We've already, the modification that we've made has already substantially reduced the resource from 53,000 odd ounces that we had in the previous application down to 45,000 ounces. You know, the new approach actually it makes the environmental and economic outcomes of the project, the risks associated with those more easily manageable. They give us time to start development, start mining before we even commit to crossing the river and diverting the streams. So that's not an event that takes place until 3 years down the track. I'd just like to point out that, as Ms Davidson already has, the project area is a highly modified environment. It has been historically mined, the total valley floor, from about 1902 through to 1935, and subsequently again by L&M mining in the early 2000s. and the legacies of those of that mining still exist on the land today, in the form of dredge ponds and even a large tailings hill, which is now grassed and part of the landscape. The land adjoining the stream is intensively farmed, subject to winter grazing. We've worked closely with the landowners of the full farms that we affect, and we have also been in consultation extensively with our neighbours, and have reached agreements with all existing neighbours. The biggest concern for two of the neighbours was loss of visual amenity, and we've addressed that through means of compensation, basically. So there was nothing much else that we could do. We've worked very closely from day one with the Hokanui Runanga. We would not have proceeded to evaluate the project if our initial consultations with council and with the Runanga and Fishing Game and Dock had been, we're totally opposed to this project. So clearly we don't want to spend money if there's no chance of us actually being able to develop it. With the Runanga, we have entered into a strategic relationship agreement, which is really basically a memorandum of understanding that we'll work closely together if and when the project is consented and we make a decision to mine. The key points of the strategic relationship agreement are that there are both, is that we will work closely with the Runanga in the development of the rehabilitation plan of the Waikaka stream and Shepherd's Creek, and that they will be actively involved on arm's length terms with the monitoring and the actual rehabilitation process, in particular the nursery development and riparian planting of the stream. There are also other economic benefits to the Runanga that come under that agreement, and such as sort of employment and support in other areas. You know, that is a relationship that we propose to develop closely, but they'll be involved closely with all aspects of rehabilitation of the Waikaka stream. Really, that sums up the project from my point of view. And what plan are you looking at?
So this plan that was provided with the application, there's a landowner plan.
Ah, yes, the grey area.
And the grey area down here is labelled as Greg Lamb.
Oh,
we don't have any written approvals from Greg Lamb, I don't believe.
No, it's Drummonds.
It's the Drummonds?
Yes.
Perfect, thank you. And my other question relates to, in the Gore District Council Section 42A staff report, they mentioned that there were a couple of outstanding written approvals from, I'm not sure if they were adjoining, but nearby.
Yes.
And in the landscape joint witness statement, they mentioned that there were some more written approvals obtained. Are you able to advise on who those parties are?
Lisa and Mari Stevenson, namely Lisa Stevenson. She was the party most affected visually. Over a kilometre away from the project, but sitting up on the terrace with a view, you know, a picture window view directly down over the valley. And depending on your perception, it would have been an interesting view, or it would spoil the rural aspects.
Thank you. And was there a second property as well, or was it just that one property?
Murray Stevenson was her mother, and it was lodged in support of this submission, but they've both withdrawn those submissions.
Okay, thank you. My other question relates to, in your evidence statement, at the very last you talk about the willingness to consider compensation if required, and you mentioned some examples of what that might look like, including a fund for re-establishment and enhancement of galaxid habitats outside the mine area. So my question is, if we find that there was a requirement for offsets or compensation. Have you developed any ideas beyond what you've mentioned here? Like, has there been discussions around what that compensation may look like with the rūnaka, or have you discussed that with your experts, your witnesses that are appearing?
We've discussed it with our planners. We haven't put any quantum on it. We have differing views on the galaxids, on Gollum. Our experts' view is that the populations that have seemed to be of particular concern to DOC are immature populations in a very degraded environment within the ditches, because they actually don't survive particularly well in the river because of the trout, which are being protected by Fish and Game. So, find it a little bit frustrating, and in the respect that the drains in which the Gollum's populations are, they don't reach maturity from our experts' point of view because of the degraded habitat they exist in. The same drains are farm drains which are regularly dug out without any consultation by the landowners. And but look, I accept that it is a significant concern, and if there is something that we can do to help mitigate that, we're willing to address that. But we haven't got anything specific.
Thank you. And this might be a question for Ms. Colley, but in terms of that, so depending on what we hear in terms of ecological evidence, and clearly we have some things to think about in terms of the NPS fresh water and how that applies in terms of the drains and that is something that potentially the applicant is
Yes.
would be considered to volunteer.
And there might be others who might answer this. One of the things that intrigued us in the application was that the reliance actually on management plans.
Sorry?
The reliance on management plans
Yes.
to deliver. And a question I have is, given some of the time that's now been given to conversations, would it have been worthwhile in now thinking to have, or why didn't you actually write those plans prior to the application and deliver them as part of the application?
Two reasons. One is resources, right? At this stage, we've spent substantial sums with a great deal of uncertainty. So there's a finite amount that we're going to spend before we even know we're ever going to be able to mine. Secondly, once we make a decision to mine, we have the engineers, the geologists, the consultants, we have the cash flow to be able to prepare the plans in detail in consultation with other parties. So a lot of, in our initial evaluation work, a lot of it clearly focuses on the economic viability of physically mining the ground, right? Knowing and assessing the effects and knowing that we're going to have to address those. And our management plans are, at the end of the day, they're a matter of consultation and satisfaction of the concerns of a number of the parties, not at least the actual landowners themselves, which some people tend to seem to forget that we also have to satisfy the concerns of the landowners whose lands we're mining on. So the management plans are things that will evolve as we mine over the first 3 years. And I think our track record speaks to our ability to be able to develop these management plans as we go. So in our relationship with the landowners, for example, we are required to prepare a work program that we consult with them on the work program before we put a spade in the ground. And that same consultation process will be taking place with the other stakeholders as well. So there won't be several separate plans, there'll be one coherent plan that addresses the concerns of all parties.
Thank you. Thank you. Do you have a follow-up?
Thank you, Mr. Batt. Conveniently, again, off the back of your last few remarks there, I was wondering if you could step us through the process for the rehabilitation of the land itself to ensure that it maintains its highly productive land classification.
Well, yes. I mean, this project is unique in as much as there are two components to it when it comes to rehabilitation. One is the rehabilitation of the farmland, and we're very familiar with that. We've been doing that for a long time. And the other is the rehabilitation of the Waikaka stream, where we rely heavily on our experts' advice. And on a totally unrelated matter, that's why we've proposed that there'll be a dual approach to bonding. One is the underlying disturbance of the land and restoration of the land back to what it was before, and the other is the rehabilitation of the stream. Now, I think, I don't know whether it's been, I'm sure it's been in some of the reports that go in with the application.
For my questions.
Okay. One more here.
Thank you. You mentioned the dual approach to the bond.
Yes.
And I was interested in how far along the thinking is on that. The current condition that we have in front of us seems to focus on just the site rehabilitation and closure, and doesn't account for the progressive bonds for stream diversions. Is that something that has been in discussion with your witnesses and with the council, or?
We've had a joint meeting with Doc, Lynn's, Anita, Gore District Council, ES. Oh, and yes, NZPA and MB on that. The quantums haven't been fixed.
Okay.
I've prepared figures and have tabled those figures for discussion, and some parties would like there to be an independent evaluation of those bond requirements, and I'm sure that will happen. Anyway, we don't dispute the need for bonds, and we see the need for a bond that actually covers the rehabilitation of basically the pastoral land that's disturbed by mining, and one that covers the longer term rehabilitation of the stream.
Thank you. And so in that sense, what I'm hearing is that there's no dispute perhaps on the legal mechanisms,
No.
that there can be a mechanism that is agreed.
Yes.
It's more just ironing out the quantum and the metrics of that.
Yes.
Okay.
The intent is that the bond covering the recovery will be life of mine, and the bond covering the stream will be lodged before any diversion takes place, and will be progressively increased as the length of diversion increases, and reduced as we progressively rehabilitate.
Thank you.
Thank you. I have no more further questions. So we're ready for the next witness. Thank you.
Thank you.
Yes, thank you. The next witness is Mr. Heller. Thanks. Oh no.
Sorry, who was that?
NSB said that he cannot hear us.
Can we perhaps get confirmation from the others that they can hear us?
Yes, it's Paul Webber here. I can hear you guys. Just the commissioners' microphones are just a little distorted, a little hard to hear.
Okay, thank you. Doesn't seem to. Is it distorted in the room? No. A little bit. Perhaps we stand further away or closer. Maybe closer was better. Okay. I'll bring it right to the front there then, in that case. But we still haven't resolved the fact that Mr. Espy can't hear. I wonder.
The RFIs that the panel will probably have in their electronic bundle. So that's very clear where there has been some toing and froing between council and the applicant over those, mainly technical issues. Point 5 is that the potential environmental effects of the proposal and in my area of expertise, I can still confirm that they will be of a small to not measurable nature, and otherwise, and also they can be efficiently managed and mitigated with appropriate conditions of consent or within specified within activity management plans, and fully understand from Mr. Batt that they are a work in progress. So any outstanding matters, and this is probably more so resulting from parties' evidence in chief to this hearing, and that's in terms of groundwater take for dewatering and discharge of water, of mine dewatering water. We have discussed and agreed upon those matters in the expert conferencing as requested by the decision panel. The expert conferencing for hydrogeology and geochemistry the witness statement has been provided to the decision panel, and both Ms. Badenhop and myself agree that the remaining matters of the application, we considered that they could be addressed by inclusion of appropriate conditions of consent and or being specified within activity management plans. And I'd just like to include on that, Commissioner, that Ms. Badenhop and myself, whilst we haven't provided conditions of consent per se, the wording of conditions or the specifications, we have clearly indicated the content of those conditions within the joint witness statement. And I'd imagine that in terms of conditions or that ongoing conditions proffering, that Ms. Colley will probably address that in terms of the process for that. I think it's already been briefly discussed. But just the last item is, last point, that I didn't see any specific outstanding matters pertaining to my area of expertise within the submitter evidence that was from Department of Conservation and Fish and Game. They tended to focus more on the surface water, stream diversions and so forth. Thank you.
Certainly. Thank you, Ms. Daly. We will have some questions. And Ms. Davidson, you might have a thinking in this. This is a good example where, without the conditions in front of us, we can't check that Mr. Heller's advice and recommendations have landed. We might need to think of a suitable mechanism where you might be able to get a response from each witness to that effect, either as part of the reply or earlier if we can, or perhaps some other later date. So I think who was first?
Thank you, Mr. Heller, for your summary. I had a couple of questions for you. Mainly, it's suggested, I think it was in your evidence, that it might be possible to set aside the clay layers and then during backfilling of...
The thing is, I think at your paragraph 42, you say it is unusual, the configuration of the groundwater and the geology, the hydrogeology. I think if I come to that,
42.
yeah, it's significantly different to that of a typical alluvial gold mining operation.
Yes. Yes.
Can you further elaborate on that?
A typical alluvial mining operation would be in the likes of, say, let's take an example of say a recent mine that's been authorised, Hawkswood Mining Limited at Millers Flat, and that I think one commissioner here was on that panel. So that is truly an alluvial mining project. The alluvial sequence is essentially from the top to the bottom, and that's intrinsically linked to the river, albeit it's a rather large river, the Clutha. And that's as opposed to this type of mining, which it's not an alluvial sequence from top to bottom. The best classification for the alluvial sequence is perhaps the top 2 metres. And even that's not truly classified as a very porous alluvium. Then you've got a very large thickness of clays, and then you get to essentially, which is the mine or the gold bearing layer in the lower confined aquifer. So it's certainly quite different to mining an alluvial situation beside a river, because the connections to the lower don't exist, whereas in the alluvial they do.
Okay, thank you. I think that sums that up. Thank you very much. Thank you, Mr. Heller.
Okay, thank you.
Thank you. We will call Mr. Webber next. So just confirming you can hear us, Mr. Webber.
Yes, I can. Can you hear me?
Yes, we can. Thank you.
Thank you.
Mr. Webber, we're just making a few minor adjustments in the room, hopefully for your benefit, with regard to sound. Can you hear me okay?
Yes, I can.
Okay. And we can hear you okay, so perhaps we
Yes.
can proceed.
Okay, thank you. Mr. Webber, do you confirm that your full name is Paul Anthony Webber and you have the experience and qualifications set out in your statement of evidence dated 19 November 2025?
Yes, I do.
And can you confirm that you prepared that statement of evidence and a joint witness statement dated 1 December 2025?
That is correct.
And I understand you have some minor corrections to make to your evidence, which you'll address the commissioners on shortly through your slide deck.
Yes, that's correct. There's a slight typo. It has been repeated incorrectly in later tables, so I'll step the commissioners through that.
And on the basis that that correction is made, do you confirm that the evidence is true and correct to the best?
High pirate is high. If we go back, we can see the quantity of pantails. If you can see my cursor, apologies if you can't, is around about 40 tonnes, so not a huge amount of material. Classification-wise, we use international classification processes which identifies what materials could generate acid. We have the pantails, we have that top of the gore lignite measures, the gore lignite measures down the bottom, and also those carbonaceous clays that are contained within the overburden. The benefit of the pyrite being associated with the carbonaceous clays is often you can see them because of the darker nature. So that would be part of the management process. We also looked at the water quality risks for the project. When you bring all the information together and do your acid base account for the project, its overall non-acid forming, the project NAP is minus 140,000 tonnes. So we're not expecting significant acid rock drainage, but we did run columns to understand that, and we ran columns on the problematic units being the gore lignite measures. From that, obviously we had significant oxidation, and we had the mobilisation of metals. So to simplify it, we use a process called the metal ecotox quotient, which is just simply dividing the maximum measured concentration in those columns divided by the water quality limit. In this instance, we use ANZG, 95% trigger values, which identifies metals from top down to bottom that would be the most elevated in waters affected by sulphide mineral oxidation. The ones that I see as potentially of concern if management isn't undertaken properly is cobalt, aluminium, copper, lead and zinc. The others are likely to be well below detection limits considering the dilution associated with this project and also scaling of column leach test data to the field. That was the basis for then developing the water monitoring program, which, as Mr. Halley indicated, would be at 3 locations. They've been identified as WO1, 60 metres downstream, WO2, 10 metres upstream in the Waikaka stream, and then WO3 is that discharge point from the terminal sediment pond. Our advice is, after looking at all of the project layout and materials, is that the ex-pit storage of PAF could be problematic, hence ensuring there's good management procedures for PAF materials until they're disposed back in the pit. That would involve constructing the SPO1 stockpile to minimise oxygen ingress and performance monitoring of it. For the backfill, similar approach, but obviously it's going under the long-term water table, so essentially once you blow the water table, oxygen can't get into it. We've also looking at construction in short lifts to prevent crane size segregation during the construction process before it's flooded. There's the ability to add limestone as part of the pH correction if required, and then ongoing performance monitoring of the active pit pond and also the terminal pit pond as it fills. The other risk is surface waters could be affected by AMD, hence performance monitoring will provide guidance on that, and if required, limestone can be added, and in the likely event that if things aren't managed appropriately, you could also look at limestone dosing. Sorry, calcium hydroxide dosing or something similar, caustic. Although not written, one of the questions coming back was, what does an AMD management plan look like? So we've created a number of these for companies here in New Zealand and internationally.
Am I confusing the two types of monitoring here, or are they the same thing?
So I think in that table, would you mind if I shared the table again? If I bring back up the slide deck, would that help?
Is that table 4 in your evidence? Oh yeah, we'll put it up anyway. I'm happy with that. If it's
no, I've got it. No, that's all right. Everyone's got table 40. I'd rather it was table 3, which is paragraph 18, which is the clearer one without the correction. That's all right.
Certainly, yes. We'll look at table 3.
Yeah. So the performance monitoring is to look at sulphate and look at EC, and when you have waters that are impacted by acid and metalliferous drainage, they're going to be impacted by sulphate. So if they're significantly impacted, you would have high sulphate. You're also going to have high EC. So the performance monitoring can be undertaken, and hence one of the reasons for having weekly sampling is you get a really good data set that can then provide guidance on what those other constituents will be. So for instance, The cobalt or the copper, they would be associated with pyrite oxidation. So if your pyrite's oxidising, you would have sulfate released to solution. The iron's probably going to drop out in the circumneutral waters, but those trace metals can continue, but you would still have a relationship with sulfate. Hence, the performance monitoring would help identify those trends, and then the metals have been identified as compliance monitoring to ensure that that the concentrations in the discharge or downstream in the mixing zone are compliant with whatever limits the ecologists agree on. And in regards to those metals, the reason why we agreed on a review after 6 months is that some of those metals, once they actually get into the operations and disturbing the core lignite measures, it may actually be a null result. So there could be a whole lot of monitoring for no reason. The agreement was then perhaps that weekly could be dropped to monthly, and that data then be reviewed on an annual basis.
Thank you. That was a helpful explanation for me. I noticed that you pointed to the ecologist for the sort of in-stream limits. Would they be applied in the AMD plan?
Yes, so if you think back, the first step of the AMD management plan is, understand the closure objectives.
Yes.
Which a key one is water quality. So all the engineering controls that would be proposed, the characterisation, prevention, minimisation, control and treat, are designed to achieve those objectives. So it's part of that plan.
And I noticed you've used the...
correction, it's referred to in that plan, obviously. Others would come up with those limits.
Thank you, yes. And I noticed you've used the ANZDG limits in your exercise. Are they the limits that you would expect to be in stream?
Often when we come into a project like this, we come in early because our tests take a while to do. So we need some context or some understanding of what potential constituents of concern are elevated. So as a default, we just use ANZG, 95%, which provides us guidance. Obviously, once those actual limits are agreed with, the site-specific, all that sort of stuff, we can then introduce those into the MUQ to have a better understanding. As per our report, it's just done as a screening tool.
Okay, thank you. That makes sense.
I'm in your hands as to whether Certainly. You would like to break or keep going.
Well, I'd like just to clarify, the ecologists coming in together, is that time for 1 o'clock? Because that will have one person online, and we've got Mr. Strong and Mr. Espy. Have we? I don't know. What do you think? One more at least. Yeah, I think we'll keep going.
Keep going.
Yes. I mean, we can shorten a lunch break if needed. Yes.
Thank you.
When you're ready.
Thank you. Mr. Strong, can you confirm your full name is Raymond Blair Strong and you have the qualifications and experience set out in your evidence dated 18 November 2025?
Yes, yeah, I can confirm that.
And you undertook expert conferencing with Mr. Stocker and signed a joint witness statement dated 26 November 2025?
Yes, yeah, I can confirm that too. Yes.
And do you have any corrections to make to your evidence?
No.
No. And on that basis, do you confirm that the evidence is true and correct to the best of your knowledge?
Yes, yeah, I do.
Okay, thank you. If you'd remain to answer any questions from the commissioners.
No specific summary you'd like to deliver? Again, not obliged to.
I guess just to emphasise some of the points that I've made in my evidence. In my opinion, the appropriateness of the design standard that's been chosen, that containment of that 20-year return period event, estimated 20-year return period event. It's the technical work comprehensively covers both the sequencing of operations and broader effects. And I guess just to note, as I have done in my evidence, the modified nature of the environment. So obviously channels have been shifted and moved in the past, but also some of the other features that I referred to in my evidence, the old railway line out to Waikaka Township as well too. Just again, the generally modified nature of the environment.
Okay, well, thank you. I'm not sure who's first now. Oh, it's you. I'm trying to alternate, as you might imagine.
Thank you, Mr. Strong. Look, I have no particular questions. It's all quite clear to me. The joint witness statement, there seems to be consensus there. One, I guess, overview question is that clearly you've looked at the conditions of consent. The aspect that was recommended in terms of adding channel maintenance to condition, you considered was a worthy addition and had merit?
Yes.
Yes. And could you just talk me through the significance of the addition of that clause?
So that's channel management after the channel has been returned to its position. So there's obviously a sequence in terms of moving the channel and then relocating it back to its original position. And so again, it is a modified environment. There isn't necessarily a natural alignment with that reach of the Waikaka. And there is obviously a settling down period that will inevitably happen once you return it back to its original alignment. It just makes sense, I think, to have a willow is not particularly desirable in this environment. Willows are used a lot in river management activity throughout the country, but those are generally in larger, more active river systems. My comments were really made in the context of Mr. Stocker's evidence and really talking about extensive willow clearance basically occurring at the start of project commencement. And I guess I was trying to express a view in my evidence that I think that needs to be done judiciously. No, I'm not saying willows are perfect in this context, obviously, but and there certainly will be extensive areas that can be removed, but it needs some consideration on site. Wouldn't want to go through with a scorched earth policy in that regard. I used to talking to Mr. Stocker, he did pick up the point that I hadn't quite picked up, and that was that I think there was some advocating at of replanting of crack willow once the streams have been returned to their original alignment, if I have that correct. And Hank was obviously not keen on that idea, and I wasn't particularly keen on that idea. I think the intent is to have propagated willow species rather than crack willow in that regard, and I'd certainly support that. I have no problem with propagated species in this environment. It's just crack is very invasive and congests waterways. Latin name Salix fragilis, so even though it doesn't seed in New Zealand, it spreads just literally by fragments moving downstream and taking hold. And so,
And just to be clear, your comment on undesirability is from a river geomorphology engineering perspective.
Yes, it is. In terms of capacity, conveyance, debris load, all of those sorts of things. Yeah.
Thank you. That's good to have a view on that. Thank you. I have no further questions. Are we all good? Yep. Okay, thank you. Mr. Strong. If Mr. Espy is on, we don't have many questions, I don't think, from Mr. Espy, so we could deal with that quite rapidly, I think, and then we can adjourn for lunch.
I'll just make sure Mr. Espy is there.
Yes.
I think he's on screen, but just make sure he's listening. Ah, there he is. Mr. Espy, can you hear me okay?
I'm finding it difficult, but I can hear you, yes.
Okay, I'll speak. That's a bit distorted, but is that okay?
Sorry.
Okay, I'll make sure I speak right into the microphone. Is that okay?
Yeah, that's better, thank you.
Thank you. Can you confirm for the commissioners that your full name is Benjamin Espy and you have the qualifications and experience set out in your evidence dated 18 November 2025?
Yes, I do.
And you undertook expert conferencing with Mr. Moore and prepared a joint witness statement dated 27 November 2025?
Yes, correct.
And did you have any matters which you needed to correct in your evidence?
One matter which is probably best looked at in the joint witness statement. If we go to paragraph 3C of the joint witness statement, there, paragraph 3 really lists the various bits of landscape assessment commentary that have been done, and 3C talks about a Vivian Espy memo dated the 25th of February. The final version of that memo actually is dated the 1st of April, and that's the more recent and correct version.
Okay, thank you, Mr. Espy. And with that,
Moore and myself were envisaging that those conditions might also just ensure that details of species mixes, plant numbers, and that sort of thing were included. So I know there are previous conditions that require an ecological assessment of the current situation, the current condition, and so I think if when that details of rehabilitation design come into the council, it would then be an achievable and easily achievable, hopefully, exercise of them determining whether there's at least no net loss.
Thank you. That's helpful. No further questions from me.
Thank you. Thank you, Mr. Espy. I have really just one question, and I'm going to return to this question of the willows planting. How much does planting of willows, whether they're crack willow or shrub willow, is it reflective of the natural character, or could that be removed from that plant mix if that was desirable?
Well, from a purely landscape perspective, leaving aside things like habitat and ecology and what have you, which I'm sure are important as well, from a purely landscape perspective, I don't see that willows are a necessity. They certainly, we need to avoid crack willows, but replacing with willow, of course there's been willows along those watercourses for a long time, and replacing those willows with some other planting would bring about the same degree of natural character that has been the case for a long time. It's a sort of a modified rural farming type of natural character, which is still a pleasant character, of course. If the willows were removed and it was exclusively native planting along those watercourses, that would be an improvement in natural character, I would say, and would be a good outcome landscape-wise as well. So from a straight landscape perspective, I wouldn't say that the willows are a necessity, but they might be a necessity for other reasons.
Thank you, that's very helpful. Thank you, Ms. Espy. I don't think we've got any further questions. Thank you for joining us today, and
Thank you very much.
And you can be excused. So that might bring us to an adjournment for lunch. Let me check the time. If we can be back here at 1 o'clock, is 40 minutes enough time to get lunch locally?
fine. I'm not sure.
Not sure.
I'm sure that will be fine.
Well, we'll aim for 1 o'clock. Thank you.
Thank you.
No, 'cause there's a whole heap of documents came through about 11 o'clock. I was refracted to reading them. Yeah. Okay. Yes. Yeah. Okay. Yeah. So that's directed to people when they pose questions when they go away and answer, or? Okay. Oh, right. Okay. See if there's consistency or not. Right. G'day, Guy. How are you? Good to see you.
I'm all right.
Ross, nice to meet you. You haven't driven well through. Nice to meet you. Oh, very good. Yes. So did you travel through last night? Oh, okay. Yes. Oh, okay. Right. Oh, I think she driven over it. Okay, so I don't need that, so I just drove. Yeah. No, to be honest, the whole stuff, this should be a bit of a washout down here. Okay. Oh, okay. Thank you. Coffee or Ross?
I know, it's hard to see, isn't it? I couldn't even see from here. I'm like, oh gosh, I've got my glasses on. I don't think I can get any stronger than they are. So.
I actually struggled to hear your increase.
Really?
Well, I'm deaf at home.
Oh, right.
So far back, but
We'll give you a written copy so you can read
No.
it at your leisure.
yeah, right.
Because I know you really don't need to sleep tonight.
No, I picked up that.
You can't actually turn away from the microphone because I could tell Ben couldn't hear me unless I was talking right over.
Yeah, no, you've got to be
definitely
very
represent the
careful.
room.
Yeah.
Oh, hello. Yeah, you are.
1,100.
Did you find very good strays for lunch?
So really?
So what? So rush to find something to do. Make sure you get there in half an hour.
Where's that?
Did you travel through any city?
No, I can't.
Oh, okay. Oh, right. You need to return home to stay, will you?
No.
No? Oh, okay. Yes. Yes. Oh, okay. Right. Oh, right. I can see the photograph already. No, that's my understanding. Yeah. So I have.
And you confirm to the best of your knowledge that that evidence is true and correct.
Yes, it is.
And you also participated in expert conferencing and signed a joint witness statement dated the 28th of November 2025.
Yes, that's correct.
And I have noted for the commissioners that the applicant's intention is that that be treated as essentially minutes of a meeting as opposed to a formal joint witness statement, so I won't ask you to confirm that that is your evidence.
Okay.
Thank you.
I might just pause there. I'll just ask you to introduce yourself by name. I don't think you've got anyone to introduce you.
No, I can be happy to do it myself, if that's
Okay,
all right.
yes. It's just a formality.
Yes, no, I understand. Good afternoon. My name is Jacob Smythe. I'm an employee of Fishing Game and I'm here on behalf of that organisation. I have tendered, full disclosure, I prepared the written submission on behalf of Fish and Game. I've also tendered a brief of evidence dated the 26th of November. I've done that as a witness with expertise rather than as an expert witness, with reference to the fact that my experience comes from my practical experience with Fish and Game as opposed to having originating technical qualifications. My original qualifications are in matters other than freshwater ecology, and in addition I have participated together with both the parties sitting next to me and also with Mark in the conferencing on the 26th and 28th of November from memory.
Thank you.
That was very short and sweet.
No, that's just what we need. And yourself.
My name is Jen Bell, I'm a freshwater.
Oh, so, excuse me, I wonder if you can just put the microphone on it and speak a bit closer to it or pull it towards you. Oh, it's not working. Perhaps we can just move on over for now.
Kia ora koutou, my name is Jen Bell, and I'm a freshwater technical advisor for the Department of Conservation.
Thank you. And is it Mr. Hamer? Am I saying that right online?
Kia ora everyone, Mark Hamer here for the Southland Regional Council. Is that sufficient?
Yes, that's fine. Right, we'll get underway. So, Mr. Dungy, if you'd like to kick off and read any summary statement you might wish to.
So, if I'll go through my summary of evidence. So that's the one dated 3rd of December.
Yes, you can start at paragraph 5 on that one, I think.
I have assessed the ecological values and water quality in the Waikaka stream, ponds 2, 6 and 7 as affected by the mine and the ditches in the proposed mining footprint. In terms of the existing environment, Waikaka stream, as noted in the joint witness statement, it rates as high due to the presence of long-finned eels under the EIA-NZ assessment methodology. On other methods it rates as poor, that's the SQMCI, good for the MCI, which the invertebrate indices. I consider that the overall habitat quality for Waikaka stream to be good. For Shepherd's Creek, my evidence identified this as having lower ecological carrying capacity compared to Waikaka stream. The same fish assemblage is found as in the Waikaka stream is expected to be present in Shepherd's Creek. That is longfin eel, upland bully, brown trout and galaxids. And Mr. Hamer's evidence is that he observed galaxid fry in the stream at the confluence with the Waikaka. The presence of these species, longfinned and galaxids, means that the Shepherd's Creek rate has a high value under the EIA-NZ methodology. However, I consider there is a significant opportunity to improve habitat in Shepherd's Creek, as the biotic indices I have measured for Waikaka stream are, in my opinion, at lower levels in Shepherd's Creek. With regard to the ditches, those with permanent water rate as high as proposed, which will result in improved habitat in Shepherd's Creek and as good or better in Waikaka stream. Specifically, the use of clean gravels and cobble substrates, which improves interstitial spaces and water percolation, improved riparian planting and the inclusion of backwaters within the existing footprint. In my view, these are enhancements which will hasten the recovery and provide overall improved outcomes compared to the current situation. This is particularly the case for Shepherd's Creek, but also applies to Waikaka stream. The joint witness statements included comments on conditions. And I comment as follows. With regard to condition 30, my opinion is that it is not necessary to avoid works in the Waikaka stream or Shepherd's Creek in December, as juvenile fish of all species are quite mobile at that time and can be salvaged or washed out with stream flow as diversions are undertaken. I am happy that the words "unless a suitably qualified ecologist" could be removed from the condition. Condition 38. This currently provides for monitoring for an initial period of 3 years. The experts agreed this should be extended. My suggestion is that monitoring be in years 1, 3 and 5 following diversion back into a rehabilitated channel. Having said that, if a monitoring after 3 years shows the reach was not on track, that's, sorry, typo there, was not on track to achieve at least no net loss, it is very unlikely monitoring at 5 years would show a decrease in habitat quality. A 5-year time span allows for habitat features to mature and improves the resolution capacity of the biotic indices being measured. Condition 39, the agreed column of the joint witness statement includes the words, within first paragraph add lowland hardbed threshold levels rather than comparing to pre-mining levels. On reflection, this does not fully capture what I agreed to. The lowland hardbed threshold levels should refer to sediment specifically rather than all the water quality standards in those thresholds. Many of those would be outside the control of the consent holder. The first part of the condition should read something like, a monitoring report shall be submitted to the Consent Authority and Hokanui Runanga within maybe 3 months of each round of annual monitoring required by Condition 38 and shall include all results comparing pre-mining baseline levels except that sediment shall be compared to lowland hardbed threshold levels as an additional assessment of ecological quality. Section D, addition of fish and game and dock to conditions. I note that I agreed to including reference to fish and game and dock in a number of conditions. This is on the basis that I see no problem with their inclusion, rather than me considering this is required to address an ecological effect of the application. Strictly speaking, who should be consulted on the management plans, etc., is not a matter within my expertise. In conclusion, while I understand some witnesses are less confident than I am about the prospect of rehabilitation being fully achieved, I remain confident that rehabilitation will be well on track within 5 years. The time taken to develop riparian shading to the extent currently on the Waikaka stream will mean full recovery may take a little longer. Given the habitat features to be enhanced, such as extended riparian planting, clean substrate, the addition of backwaters, an increased proportion of riffle, I consider it likely there will be an improved outcomes for the Waikaka stream, the terminal pond, and particularly Shepherd's Creek. I am happy to respond to questions from the commissioners.
Thank you, Mr. Dungy. Questions now.
The application and talking about the receiving environment, you mentioned that there's waterfowl present on site, which we saw during the site visit as well, and was wanting to understand if you thought there would be a need or value in having a bird management plan.
Off the top of my head, I guess I would have to say first of all that I'm really a fish biologist, not a bird biologist. But I think my feeling would be that most of the species that are present are highly mobile and pretty used to disruption, perhaps, or responding to human activity and presence. So, and I didn't encounter any native species that would have sort of raised alarm bells for me that we need to be doing something particular to look after these.
Thank you. That's my questions for now.
I do have a couple of questions, and I have a number which we'll address to each of you as well. Just on the question of avifauna and birds, on the ponds, there was a statement I think I saw in there a year about waterfowl. And we saw the ponds, or the 3 ponds that are going to be removed. In your view, and I appreciate you're a fish biologist, but as you're looking, were there any suitable bird habitats in the margins of those ponds that might be home to some sort of cryptic water birds?
There are quite a few of the ponds that are fenced off, and so they do provide good waterfowl habitat, but I didn't notice anything like fern birds, once again, not that I specifically looked for them. So most of the occupants, the common occupants of the ponds are mallards and a few teal and perhaps a few paradise ducks. and I'm sure they use some of the wetland vegetation around the ponds for nesting. But once again, I didn't specifically look for them.
Thank you. We might come back to that. And just coming through to the rehabilitation process, because the diversions are staged to happen at different times, my understanding is, and please correct me, is that as the diversions are completed and we go back to rehabilitating the stream, that will happen as other diversions are occurring downstream. Am I correct? And there'll be
yes,
kind of overlap of those activities.
That's my understanding, yes.
Yes.
So the diversions are staged, and so the rehabilitation will be staged as well. So as one diversion is done away with, then that channel will be a new channel will be rehabilitated, but there might be another diversion being developed at another location. And that's that schedule. There is a schedule.
Yes.
Yeah.
Yes, that's right. Just clarifying. And so the first rehabilitation in that 5-year period you talk about may in fact be complete before the last one, whilst that one's still underway perhaps.
Yes, yes, that'll be my understanding.
So it's staged as we go. That's helpful. That
yes.
is helpful. Yes, thank you. As I said, I've got a number of questions which will be put to probably to each of you. And just in your view, I was just intrigued, where we've got the temporary diversions and we're hearing that there may be some habitat improvements within those, or some features added to them.
Yes, so that would sort of provide a little bit of an opportunity to do an extra check on whether or not this particular feature that we've introduced to the diversion channel is is attractive to fish. So it's whether or not it's a habitat improvement.
1st of May through to the 31st of October, or alternatively through to the 31st of November. And certainly from a brown trout perspective, the proposed succession date of the 31st of October is suitable in my opinion. With respect to habitat loss and recovery time, diversions will remove existing in-stream habitat and overhead cover. Important in-stream habitat features such as undercut banks, shading, root masses and woody debris will take years to naturally recreate. In this case, the effects of reduced shade could be an increase in in-stream water temperatures and poorer habitat until full colonisation of riparian vegetation. With respect to crap willow management, it is a key ecological and angling feature due to its production of the willow grub as a seasonal food source. The proposed hybrid willows will not produce the willow grub. In my opinion, preventing crap willow recolonisation will be difficult and require ongoing commitment given extensive upstream sources of vegetation. In my opinion, the reinstated channel must recreate diverse habitat and increase low flow sinuosity. That said, I concur with my colleague to my right that the diversions do provide an opportunity to restore a more natural sinuosity and pull run riffle pattern. Turning to recommended amendments with respect to consent conditions, and I don't intend to reiterate all that I agree with, just simply matters where there is appropriate further consideration. As I said, there is agreement that as a minimum, in-stream work should be prohibited from the 1st of May through to the 31st of October. With regard to conditions 33 and 36, given Fish and Game's statutory responsibilities, I believe there's merit in extending the scope of those conditions to refer specifically to Fish and Game with respect to channel design and also habitat reinstatement. With respect to the proposed increase in riffle habitat and channel sinuosity, in my opinion there is merit in a degree of specificity with regard to the size of spawning gravels, specifically a size range of 10 to 50 millimetres in the proposed increase of riffle habitat, and a strengthening of the conditions with regard to the riparian rehabilitation. I do note that I think from Ms Colley's evidence the proposal is for 5 metres, but there seemed to be a tension between the evidence of Mr. Batt, which showed potentially up to 15 metres each side. So I guess it's the degree of specificity that is required. In my opinion, there is benefit in extending the ecological monitoring from 3 to 5 years to include also annualised GPS mapping of brown trout serving sites, principally as a mechanism to monitor utilisation of the riffle habitat and the degree of that utilisation. I gain the impression that there's now a strong measure of agreement with regard to the imposition of a bond to cover the stream diversions, not just the land rehabilitation. The uncertainty, I guess, in my mind is simply the quantum of that bond and what is appropriate. Overall, if consent is granted, there is the opportunity for strengthening of consent conditions with regard to timing, design, reinstatement, monitoring and the financial bond to adequately protect the Waikaka stream fishery with respect to its brown trout values. I would like to depart from my notes just to answer a question with regard to waterfowl, if that is coming, or to pass some comment, if I may.
Well, there was a question that would come, yes. So
oh, okay, sorry. In that case, I'll wait for it.
No.
No, I just want to say, make the observation.
It's in Fish and Game Camp, so
yes. This is again, spawning is at the head and the toe of the riffles, often at the toe where there's maybe a pool, for example. And certainly, what we see in other tributaries, particularly ones that have limited spawning gravels from historic over-excavation, is that there can get a thing called supersedure, where brown trout hens will spawn over the top of each other. And create multiple spawning sites or nests, and they're certainly physically observable. You tend to see very little spawning through pools, particularly just simply because you don't have that velocity of cool water.
So those riffles, are they spread kind of equally throughout that reach in your
well, typically you have a sequence, so you'll have a run riffle pool sequence, and one of the issues that you do get with high degrees of historic modification is effectively you tend to have lots of long riffles with limited pool and often very limited riffle habitat. And an extreme example in Southland would be Channel Road on the Makarima, where it is a dead straight channel for a matter of kilometres, and that wouldn't provide ideal spawning habitat. The advantage, one of the main reasons why spawning habitat, there's good spawning area, is simply the size of the gravels themselves. Hens can't typically mobilise larger than 50 mils. If you went and had a look, for example, at the Matilda River down at Gore, you'd find quite large substrate, typically sort of maybe up to 30 centimetres, for example, and extensive exposure of the underlying lignite bed. Yeah. Sorry, very lengthy answer to a short question. So.
Well, yes, I'm not quite sure it's quite answered it, really. I'm just trying to understand, is there it sounds to me like all of the river has those features of one sequence or another. And we might come back to that question anyway.
Okay. I think the answer to your question, though, is that the extent of riffle habitat has been reduced over time through the straightening process by conversion into long lengths of run habitat.
Okay, thank you.
Thank you for your summary, Mr. Smith. I had a question regarding willow grub, and
yes.
You mentioned that it's a seasonal food source.
Yes, correct.
So firstly, what time of the year is willow grub present and available as that food source?
Yes. It's principally associated from the summer period, really from mid-December through to mid to late February. It's quite a discrete period.
And then a follow-up question regarding that. What other food sources are also likely to be available within the stream and the riparian margin at that stage?
Well, there'll certainly be the presence of other invertebrates, particularly like caddisfly, stonefly, for example, mayfly. And so what we see, though, is that in terms of trout behaviour, that they tend to feed on that dominant willow grub population. I think the reality is, given the extensive upstream sources of crack willow, it's going to be very difficult to prevent recolonisation.
Thank you. I think that was... Yeah.
Thank you, Mr. Smythe. You mentioned the bonds. situation.
Yes.
So I see in your primary evidence you sought, it would appear that the relief sought by Fish and Game has been met by the applicant.
Yes, yes.
But you had an outstanding concern, did you? Did you raise an uncertainty? Was that regard to the...
My only uncertainty is really what is a suitable quantum, particularly given the extensive nature of the rehabilitation that we were required. We're talking up to 3 kilometre reach of the stream.
Thank you. And do you have experience in these sorts of conditions and what kind of quantums might be involved?
No, I couldn't pass any comment on that.
No problem, thank you.
No, and to be a guess.
Yeah. Inform the parameters of your assessment, in some sense, that if there are temporary effects, would that constitute an material harm when you think about the rehabilitation and the mitigation and remedying of those effects over time?
Do you have a definition of material harm? Is there like a legal definition of material harm, just so I can be accurate in my answer?
That is a question the chair did ask.
But your response we got was no, particularly. Definition, no. So it's a contextualised, I think, within the project and the circumstances and the actual effects.
Yeah.
So yes, I mean, I can't explain that to you.
Right.
I just give perhaps your thoughts. Material harm.
Yeah, no, that's...
Not residual harm, material harm to the ecosystem, perhaps we consider, or any populations of particular species. Let's focus on perhaps on those two to start
that
with.
Makes sense. One of the things that stuck out from the legal arguments this morning was just pointing out Ross Dungy has assessed that it will take time for this habitat to re-establish. It could take up to, I think, 5 years was what was proposed. Now, 5 years, is quite a long time to have had those reduced habitat values. I mean, some of these fish species don't live, an extremely long time. So, we're talking about 5 years of reduced habitat values. Not only that, if the restoration is not successfully completed in the right way, then we could have ongoing effects as well too. And as I stated in my summary and in my evidence, I just don't feel that we have the level of information. I haven't seen the level of planning and scoping and design, I guess, to set our minds at ease on that. Restoration can be done well, but it can also be done not so well. So I'm just wondering what level of restoration is going to be done. There's been some information which isn't exactly clear, like, for example, the planting of the waterway, and that was sort of shown as, we're going to improve the habitat by putting indigenous species, 5 to 15 metre widths. Something that was pointed out by Jacob at our joint witness statement meeting was actually that a lot of those riparian areas are already wider than that at the moment. And something that we discussed at the time too was actually, so Ross Dungy had actually said, and it makes sense, that it's going to be very difficult to get the level of shade required without planting considerable amounts of willows, which makes me actually wonder how much indigenous vegetation is going to be incorporated into that. So are we going to get, a net gain in habitat if we've got narrower riparian widths? And we've only got willow with very limited indigenous vegetation there. Also too, just having been involved in restoration, some restoration projects myself, it is complex. You've really got to get that planning right. Like in the past we've done, hydraulic modelling as well. I think that, does that answer it?
Well, it's very helpful. Thank you. Yes.
Thank you. And in terms of the level of scoping, planning and design that you would anticipate for such a project, is there any comfort given in consent conditions which would establish a process by which the department would be able to review and input into the level of detail and planning and design?
Yeah, so I think, yeah, we've suggested that in the conditions that would be included in, I mean, always with these sorts of projects, I guess it's, yeah, worthwhile investigating these things.
Thank you.
Okay, thank you. I do have a number of questions, but I'm going to put them to all of you. So I'll just move on for now, Ms.
Okay.
Bowen, because they're interrelated. We'll just turn to Mr. Hamer now. So thank you for your patience on screen there. I hope you've been following the conversations and the questions and the responses. And Mr. Hamer, wasn't sure whether you would want to present a summary statement.
Yeah, thank you. Yes, so please read my evidence as read, but I will make a couple of minor updates and summarise the bulk of it. So for point 7 of my evidence, I note that I've re-familiarised myself with the maps and diagrams supplied in the application that outline the current and proposed pitch locations. With regard to para 11, table 1, I'd like to let the commissioners know that as of Monday I was made aware that there's been an update to the New Zealand freshwater fish classifications, and in reviewing this, John Access is now at risk declining in Northland videos. However, I still consider the ecological values of the Waikaka stream, Shepherd's Creek, perimeter flowing unnamed ditches as having high ecological value. I consider the ditches across the site and Shepherd's Creek to have high ecological values, and that the assessment of effects was not adequate for these habitats. The proposed rehabilitation is not sufficient to avoid significant adverse effects on these waters. I agree with the ecological values.
Mr. Hamer, I might just pause you a minute. We're getting a little bit of background noise.
Background noise?
You've actually frozen. Well, it might be in the transmission. We are hearing you, so you don't need to repeat it.
No, there is a construction site next door.
Well, there we are. There's the answer.
Sadly, I made it halfway down, but in Christchurch next to a building going up. I could go to the stairwell. It might be quieter. I'll try that out.
No, you're freezing up a bit now, so we're not hearing anything. Gosh. Sounds like something quite nasty's going on at your end, doesn't it? Mr. Hamer, can you hear me? We're not receiving any transmission at all now. Sorry, Ms. Bowen, do you have a...
I was just going to say that he's not frozen on the laptop here, which is also...
He's not freezing on your laptop, do you say?
It's not mine, but that laptop
Oh, right,
is not
okay.
freezing there.
Very peculiar. I'm not an IT expert, so sorry about this. I do want to give Mr. Hamer his opportunity. Yes, that might be an idea. Again, Mr. Hamer, I'm not sure if you can hear me. Maybe turn off your video sometimes helps.
Got you back now.
Oh, I can hear you now.
Yeah.
But please feel free to turn off your video if that's going to help the transmission.
Sure.
And
Can you hear me now?
I can hear you, yes. Please continue.
You're all good. I think we've just lost connection with the...
Survive in the habitat stated. I agree that the Waikaka stream has high ecological values and the unmitigated level of effects assessed. I disagree that the proposed rehabilitation plan will result in a low residual level of effect. As in-stream rehabilitation projects such as this is not a simple undertaking, and there will be a lag in waterway shading and habitat establishment. Internationally, rehabilitation projects have focused on salmon and trout, and spawning habitat. But this site requires consideration of the atmosphere supply and complexes, longfin eels, rather than just spring trout. It will be difficult to successfully create as good or better habitat in comparable fish communities within the short time frame proposed. This was agreed at the expert conferencing that for at least the first 5 years post-restoration there will be a lost habitat. The ongoing residual effects will depend on the quality of the rehabilitation. A delay in rehabilitation, time lag before Waikaka plantings grow sufficiently to provide shade, bank stability and create habitat has not been accounted for in the effects assessment or management actions. Management actions proposed to reduce the residual level effect hinge on the undeveloped rehabilitation plan, likely to include a number of approaches largely untested in New Zealand circumstances, and I'm not aware of any successful examples of rehabilitation at this scale in New Zealand. In practice, it is very difficult to recreate a river or stream with high ecological values, and I do not believe sufficient details of how this would occur have been provided. I reiterate that I've got no confidence that the proposed rehabilitation actions will be successful. Did I lose you there?
Yes, we can still hear you. Yes.
Oh, perfect. Good, good. Right. The lower 4 lines of the Golden axis habitat densities described by Mr. Dunning in Table 4 of this evidence relate to the Nevis axis rather than Golden axis. This was considered the same species previously due to morphological similarities, but genetic analysis has determined this to be a separate species and it's reported in New Zealand classification as threatened, nationally endangered, and separate to Golden axis. So the data is not entirely appropriate to suggest Golden axis density is a low of these dishes. At the expert witness conferencing, discussion was had that outlined that if the drainage ditches were to be diverted to the Allen Pond, this would likely result in increased predation of Golden axis by perch. I agree this is an ecological concern for Golden axis and for the project. Not raised in my evidence, but discussed in the expert witness conferencing was that ecological monitoring should occur upstream and downstream of the mine treatment water pond outlet also, with trigger values and above which actions should occur. And then with regards to the comment made earlier, presentation heard earlier, just like to say that Mr. Dungy mentioned a reference where I've referred to a Canterbury River. My examples I used referred to an international review that outlines that 44% of restoration projects are not successful. I'll leave that there. Thank you.
Thank you, Mr. Hamer. That wasn't all.
Fish management plan and maybe just a heavy sort of focus on golems in there as well. Yeah, or a separate golems management plan that sits alongside us. Yeah, a more general fish management plan as well.
Okay, thank you, that's helpful. Mr. Hamer, same question. I think, did you hear the question? Okay.
Yes, thanks. Yeah, I think the ecological values would still be the same, so still maintenance high ecological values because of the two at-risk fish present. But in terms of the need for that golems plan, that probably is my need for that is definitely reduced, and maybe a wider site-wise fish management plan would be a better approach.
Thank you. Okay, that's very helpful. That's got firm views on that. I have another question. We're going to step into this question of the rehabilitation of the original channels, not the temporary ones at this stage, and the question of a rehabilitation plan that might be put forward, and what that might look like, and that might be put forward, and what that might look like I don't think we've seen a table of contents for that. Unlike for the AMD, we saw an outline of a table of contents. And a suggestion might be, and Ms Davidson, I'd be interested to know your view on this, and actually Ms McLeod who's on here, but whether there's some homework to be done whereby the four of you collaborate on what would look like an acceptable table of contents for a rehab plan. And rather than just a table of contents, kind of under each heading, maybe a bit of a description of what we expected to be seen in each of those, so there's more clarity than just a heading or some bullet points. So it may end up being several pages of material that's furnished with that. And hopefully that might satisfy some of the uncertainties or satisfy the requirements that might be needed to form a plan. And that would be helpful to us because we do share some similar kind of concerns about uncertainties that we haven't been able to see. So that's what we're looking for that for, and you would be amongst the experts to be able to provide for that. Now, would that be an opportunity that we could see happen? That's a little bit of homework. We can talk about the timing in due course. Ms Davidson, I'm not sure, so you're nodding your head thinking that might be helpful. It would be helpful to us. Oh. No, perhaps you can just... I'm not sure.
Okay.
Oh, you got
well,
two
I've got
now.
two now. I'm nodding because I certainly understand the point. It sounds lost to you.
Yeah.
Logical to me, but I'll obviously need to consult with my client. But I completely take on board the point, and I think that the table of contents with an indication of what would be in it is much preferable to trying to guess what might be in the final plan, which I think is much less helpful at this stage. So I think that's a good way forward.
Thank you. The idea, just before I come to some responses, is that again would need to satisfy us. That's where we're going with this. That we feel that we've got enough certainty if we are of a mind to grant a consent, and that the concerns were addressed through that. So let me put that to you. You happy with that? Is there anything you want to add to that? I'm going to start with Mr. Hamer, actually. We're going to go backwards this time. So, again, and a willingness to participate in the development of that framework for a rehabilitation plan.
Yep, that's fine with me.
Yeah. Ms. Bowe?
Get to the information required to deliver an excellent rehabilitation plan would also be very helpful.
Yes, that's a good point, isn't it? Some of you have pointed out that there needs to be more data collected, and it would be helpful to at least hear that and what exactly that might look like. Any points from that?
So, did you want a response to that question now, or
No.
no? Okay.
No, we're good. We've got a pathway. This is what I really wanted to get to. That moves us through the contentions, and you've all said that that a rehab plan would be helpful. It's the amount of detail that's in it. So we're asking you, as I said before, to provide that detail to convince us that that a plan can be achieved, and the rehabilitation of the stream can be achieved, and what monitoring might be required. And we've heard some of that schedule already, and what might be needed to do if there's some failures. I am mindful that Mr. Batt has talked about a successful stream rehabilitation already. I don't know whether you want to, whether that gets to draw on that or not, I'm sure. But okay, is there anything else? Because if we're happy with that, then the other thing is with that plan is then we seem to have agreed that it's still worthwhile doing a Gollum Galaxy plan or a fish management plan. I'm less concerned about receiving contents of that than my fellow commissioners, because fish salvage plans, are reasonably well established. But I think it would be helpful if we had some indication, which might be either a map or something of where some potential relocation locations might be, or where additional habitat might be recreated. Now that will still form a condition of consent to produce that, but that would be post-consent. We're really more concerned about this rehabilitation and diversion plans. Are we all good, Ms. Bowen? You look a little kind of shell-shocked.
No.
Okay.
Yeah.
Sorry, Sue, can I just clarify, you wanted the indication of potential locations as part of before or after consent?
I think we would like to see something now, if we can, or prior to making a decision.
Yeah, I think at the very least understanding what the process for identifying those suitable locations will be, and also what the process will be if no suitable locations can be found or have
Yes, yes.
Assurances as to what the procedure will be if suitable habitat can't be created or found for those relocations, but understanding that will probably require a fair amount of design and modelling to actually firm up where those locations are. So I'm happy with not requiring that as part of this outline of management plans.
I think it would be helpful if we our views and submit another directive with this in the next 2 or 3 days, if that's okay. Yeah, I don't want to confuse anybody about what's needed and overdo the exercise. I'm mindful you want a decision because things need to move on one way or the other. Now, having got to that point, I'm satisfied myself. I think we are both. So I'd be very happy to receive those sorts of sketch material as well. And I mean, I don't want to. I'll put it in a directive, but it might be the kind of proportions of things along the reach that you're seeing where these things might sit. That kind of thing. Yeah. We will put out a directive to give a bit more guidance on that. It will say those kind of words, mine, so I've already said them. So I think we can pause there, and we'll just see how we go. And Mr. Batt, the intention is not to delay this any longer than it needs to be, but it is to provide sufficient material to us so we can make a good decision.
We understand the time period.
Pardon?
We understand the time period.
Yeah, thank you. Yes, yes. All right, we'll pause there, and I think you all excused now. If, as Mr. Hammer, thank you for joining us online. Ms. Bowen, Mr. Smythe, and Mr. Dungy, thank you for your contributions today.
Sorry, can I just one quick procedural question I may? I was scheduled to appear tomorrow. You're not requiring me to. Sorry, I was scheduled to appear tomorrow. That's been vacated now, is my understanding?
That's correct, yes.
I just didn't want to make a mistake and not appear. Thank you.
None of you need appear unless you wish to sit in the room, but we will not be calling you to answer any questions.
Thank you.
Thank you.
Thank you.
We're a little early, so we may take an afternoon tea break now. What's the time? We've got, perhaps we can until 3 o'clock. Ms. Davidson, if we take a break now and return at 3 o'clock, and we'll hear from Ms. Colley. Yes? Yes, thank you. Thank you very much. Thank you. So return at 3 o'clock.
Yeah, that was attached to the what this chap both the roof render engineering and ecological
Yes,
aspect.
so we've already, the engineering forms the framework.
Yes, yeah.
And
yes.
I think the other thing to remember, Jacob, is no matter what you create,
Yes.
the river will reach its own equilibrium.
Oh yeah, yeah, no, they're not assuming that at all, yeah,
Yeah.
yeah, yeah.
So we will create the initial.
Actually, how about I give that to you?
Yeah, that would be very handy.
Yeah.
Well, the original, not Hudson's original report, isn't it?
Yes, it is, yeah.
Hudson's, yeah.
Yeah, yeah.
Yeah.
Yeah,
Attached.
yeah, it came up with all these different things which I think was the, talking about. No, no problem. Oh, okay, yeah, yeah. To be honest, I didn't look at diversion plans too much before. I mean, there's now this quite onerous part of these wetland restoration plans, and got some good examples tonight, so this is quite different, so, yeah.
No, you've got some good examples of wetland restoration.
Yeah, yeah, yeah.
Okay.
Yeah, yeah. Because of course now for a whole lot of
Email you a reminder of that as well, just to even
yeah. Because now for a whole, even for a whole lot of these permitted activities for wetlands under the NES with regard to restoration, you still have to have these plans and yeah. Yeah, we busy before Christmas, Ross.
Oh, shit. But don't go away because I need to talk to you.
Oh, do you?
Yes.
Oh,
Sorry. I'm not going away.
Good.
it up. We were wondering if you would prefer to have sort of 10 minutes to read over that before we start into Ms. Colley's evidence, or if you're happy to box on. I just wondered whether that might be useful.
Well, thank you for the request. We just had a little conversation about that. Actually, what we thought might be useful is first you do, Ms. Colley, you take us through that joint witness statement, and whether that materially changes anything for your own evidence, if you like, and then turn to your evidence and presentation. Is that okay, Ms. Davidson? Yeah.
Yes,
I think
that sounds very sensible.
Okay, thank you. I think we're in our afternoon session now, if I can bring everyone to attention. And over to you, Ms. Davidson.
Thank you. Can you please confirm that your full name is Anita Claire Colley, and you have the experience and qualifications set out in your statement of evidence dated 19 November 2025?
Yes.
And you participated in expert conferencing on the 2nd of December 2025 and are a signatory to the joint witness statement on planning?
That's correct.
And did you have any corrections to your evidence?
Yes, I do. So there is one typo that I'd like to correct. So I've made a couple of references to policy 27A of the proposed Southland Land and Water Plan, and that should read as 28A. And
are you able to point out where they exactly are on that page?
So paragraph 250 of my evidence.
Oh, right, okay. Sorry, excuse me.
And the second place is in the appendix on page 134 of the overall PDF. So
I don't have that.
There's two references, so one on page 134 and one on page 135. So 27A should read 28A.
Just a moment, just making sure. Oh, good. Okay, thank you.
So, and then I was going to note that following conferencing and after listening to Council this morning, that there were a couple of updates I would like to make to my assessment. However, that might be most helpful to do in taking you through the planning joint witness statement.
Okay,
I think.
yep. Happy with that, whatever's most efficient.
Thank you. And with those provisos, are you happy to confirm that the evidence is true and correct to the best of your knowledge?
Yes. So just acknowledging that the Commissioners haven't really seen this document and haven't had any time to review it, I'll take you through quite slowly, but please tell me if you'd like me to skip over any pieces or would like... yeah.
I might just get you to move the microphone a little bit closer to yourself. Thank you.
So if the Commissioners are comfortable, I'll take you to the matters considered at conferencing, and unless you'd like me to go through the preliminary matters there about who attended.
No, I don't think that's necessary. I think, yes, good place to start.
Yes. So we did have quite limited time in our conferencing and weren't able to discuss all the matters that we would have liked to provide you with the greatest assistance. But we did identify matters that are generally agreed. So that's paragraph 4A and subject to the application of the conditions proposed in the applicant's evidence. And so that's my evidence, Appendix B.
Thank you. Sorry. My only comment at this point would be that the joint witness statement, we focused on the issues that are detailed in that joint witness statement, but we didn't have time to go through the conditions one by one. So where there are discrepancies that remain between our conditions, that is something from my point of view that we didn't actually confirm in the joint witness statement.
That's fine. I was just raising it for Ms. As something that I had flagged in my preparation for the hearing, so something to consider at some point.
Yes. Wonderful, thank you.
Thank you. Mr. Batts just reminded me that the
the nature of the agreement with the landowners is for rehabilitation within 3 years, and so I suspect that's where that number came from.
And I just have a question. You might need to remind me, but it was during the conferencing, was the effects management hierarchy referred to and commented on?
Yes, we'll come to that. That's under the Policy 28A discussion.
Yes, thank you.
In Appendix 2. Okay.
Yep,
so I'll take you to Appendix 2 now. And the way we've structured our conferencing was first to look at effects and then to look at policy, and we didn't get time to look at conditions one by one. On effects, we started with construction effects and particularly sedimentation and erosion management. So the matters of agreement, we discussed about condition 28, and these condition number references are the ones appended to my evidence, and that some of the additional mitigation measures that were outlined in the application would be added into the condition set to provide greater clarity and certainty on the methods to be used to control erosion and minimise sedimentation of the watercourses during that diversion activity. So some examples of that are to do this diversion in a staged way, so to do it in thirds over a period of 6 to 10 days, to do the downstream connection first, to ensure that the blockage between the stream and the diversion channel is not an earth bund, so to use some other kind of material that would not be quite so prone to generating a sediment plume. And then it was also suggested that photographic monitoring would be an appropriate mechanism to close the loop on the management of that effect, and the planners all agreed on that. Where we got to was that myself and Ms. Smith agreed, so AC and AS are Anita Colley and Alexandra Smith, agreed that subject to appropriate management and construction methodology, the adverse effects can be managed to an acceptable level. Ms. McLeod remained unsure, and she thought that she needed to consider it further. Just in the comment, so we didn't end up with any matters of disagreement on that effect, but we did have some other actions that we thought would merit further thought, which was including references to an industry standard and some coverage for grass or length of grass in the diversion channels before the water was diverted down the diversion channels, and that was to provide some assurances to the degree of erosion protection that would be provided before the activity took place.
Can I ask a question, actually, while we go through this? Ms. McLeod was unsure and wants to discuss. Did you establish a kind of time frame to a response to these things? There might be others in there as well.
It might be more helpful to discuss.
Set of conditions which are track changed and annotated, and we've had 2 dates really, the close of business on Wednesday next week, but Friday would also be acceptable, and we're just asking if you have availability to contribute to that collaboration.
Thanks. Yes, I would. I think it might Thursday or Friday would be more realistic for me, but yeah, definitely could by the end of next week. Okay, well, thank you. Well, end of next week perhaps is where we'll settle. If we get a Wednesday, that's all very good. But that's good. I did have a question that's escaped me now. Oh yes, just mindful, Ms. Colley, and all the planners, of course, we've just directed the ecologists to go away and give some thought to a couple of outlines for plans, and some of that might make their way into a condition at a later date. So we can park that because there was an expectation that that may well occur.
We can provide a draft set of conditions that relate to that management plan, and then that could be subsequently amended after the table of contents is received.
And you might have heard planned this week to provide a directive which might have some headings which you could add to that as well. Thank you.
We'll just move on to page 7 of the planner's statement.
Just a moment, just pause there.
Yeah, thank you, Ms. Colley. I just have one question relating to the comments and potential actions around sediment capture and methodologies for that. And this is probably more a question for Ms. Scoos and Ms. Smith, but just wanting to understand if either Environment Southland or Gore District Council had erosion and sediment control procedures that would normally be applied to this type of activity?
No, we don't have a document that we use as guidance. I have seen Waikato and Auckland Regional Council ones referred to as a standard. And that's under the comment action column as a suggestion that some sort of standard be referred to.
Thank you.
There's also a standard for Canterbury as well that could be applicable. So moving on to the next effect the planners discussed was fish passage and salvage and timing of works to mitigate effects on fish. We agree that an exclusion period is required on the basis of advice from ecologists, and that it would be, we did note that there was some disagreement between the ecologists in terms of what the exclusion period should be, and we thought there might be value in hearing what the discussion would be at the hearing on that. Regardless, it's simple to draft up a condition with that exclusion period in it, and then the panel's decision on whatever timeframe that might be can easily slot in there. We agree that specific fish and gollum management conditions are required, and that those matters could fit in and around those conditions 29 and 30. There were a couple of comments in there just on things that might be included in a condition for fish management plans.
Or not deviating greatly from kind of a condition. Is that acceptable to you, that kind of wording?
The concern I have is the ability to adapt that plan to I guess both the local conditions and learnings from previous rehabilitations. So, and also, I guess, more practical things like what plants are available in the nursery, and those are the key matters that occur to me right now. So I'm comfortable with wording that sets the plan as a guide, and that the intention is for a really nice, robust riparian planting that comprises predominantly natives with some willows, and we build details into the conditions that capture that intention, but just allowing a bit of room for flexibility and adaptation, I think, would be beneficial.
Well, I think that's referring to the planting plan. I meant the rehabilitation plan that we've directed the ecologists to go and do is more along those lines than the planting plan, except what you're saying.
Sorry,
I'll leave you to think of some words of how, I mean, you haven't seen that yet, but the kind of words that might be acceptable so that the condition has a framework that it's going to draw on in delivering a
I
plan.
understand. Sorry, I thought your question was in reference to the planting plan specifically, not the rehabilitation. Yes, no, and for the rehabilitation plan, I'm comfortable with that approach.
Yes, okay, thank you.
Still on the rehabilitation of the stream channels, So Ms McLeod considers there needs matters of disagreement now. So Ms McLeod considers there needs to be a net gain in order to address residual adverse effects. Ms Smith needed some more information to confirm her position on that, and I'm comfortable with the objective of net gain, but in any event, no net loss. And then we've also recorded in that column some concerns about feasibility, and that Ms Smith and Ms McLeod wish to see draft plans to provide more certainty. And that would be the draft rehabilitation plan that the panel discussed earlier today.
Correct. Yeah, that's correct. Yeah, that's my view. Yes, it's there to serve that purpose as well as convince us that it can be done.
Yep. So the next section deals with effects that are not directly related to the stream diversions. And the first one in that column on page 9 is that surface water quality effects from the discharges and appropriate conditions to manage that, including sediment and AMD monitoring. So this is the point source discharge from the tertiary settlement pond into the Waikaka stream. We hadn't had the benefit of the AMD joint witness statement at this point in time. But regardless, we were able to agree that the effects could be managed through appropriate conditions, but we weren't able to determine what the content of those conditions should be. We now have the benefit of that AMD joint witness statement, and I see it as something that we can then use to draft up what those conditions should be. And we also agreed that the location of the water quality monitoring was appropriate. And then in the comments column, we've identified that we need to consider monitoring parameters, triggers and actions after it. Yeah. Moving on to the ditches.
Just before we perhaps leave that, sorry, going back to that need to consider list of the triggers and the actions, is it your expectation that they would be in a condition of consent, or the limits that we had some discussion about, although was not resolved earlier, or that all sits in a plan, in the AMD plan?
Yes, I have a question regarding that. I understand that the size of the terminal pond is going to be somewhat dependent on the amount of settlement and volume loss in the material placed, and just want to understand, this is potentially more of a geotechnical question, but understand the implications of locking a particular minimum size of pond into the conditions.
Mm-hmm. My understanding from, and this might be something you'd like to ask Mr. Batt as well, is that a terminal pond is not certain, but it is likely. I think that conditions could be drafted to require a minimum size of pond, and if that didn't eventuate through a terminal pond, then one could be provided elsewhere within the land affected by the mine footprint.
Okay. We'll keep going. I think that's the response.
Yeah. We ran out of time to discuss effects on cultural values, unfortunately. On duration, the planners agreed that the 20-year duration is acceptable provided conditions are amended to provide greater certainty about how long the temporary diversions are in place for. And what that relates to is not abandoning works and leaving temporary diversions in place for an unrestricted amount of time. So I agree with that, and I'm happy to draft some conditions that deal with that specifically.
Thank you.
So I'll move on to policy 28A, which we've discussed at page 10 and over the page. So starting with the matters that the planners agree on, we agree that the policy applies to the Waikaka stream and Shepherd's Creek, but not to the artificial water bodies, the ditches and the ponds. We also agree that there is a functional need. We agree that there's a temporary loss of extent because the diversions are shorter, but because they are remediated to previous form, there's no permanent loss of extent. And we agree that the main consideration under this policy is loss of values for the period of time between the diversion starting and the successful rehabilitation. And that's what we've applied the effects management hierarchy to. We had minor areas of disagreement on what measures fall into the avoid or minimise categories, but we agreed that they didn't change the overall policy assessment. And we agree that there is a temporary more than minor adverse effect on rivers due to diversions. I'll move to the column on disagreements now. So the first line there has avoid, minimise, remedy being achieved as far as practicable subject to conditions. That's context to inform the comment below. So Ms McLeod and Ms Smith have concerns about not having seen a draft rehabilitation plan and that feasibility has not been demonstrated, and therefore whether remedy has been achieved can't be determined. As the remedy can't be determined, residual effects can't be determined. So that I'm comfortable that remedy can be achieved subject to appropriate conditions and monitoring. Ms McLeod noted that even in the best case scenario of successful rehabilitation within 5 years, there's still a more than minor residual adverse effect that needs to be offset or compensated, and the quantum could be higher if rehab is not successful. And then,
yeah, sorry, who's also here to present a submission as well. But the first on law was Mr. John Stringer, who's not appeared yet. Not yet, no. I'm just trying to think. Are you here for the duration of the day, Mr. Garai? And Ms. Colley, I'm not quite sure how much longer you might need to go through your...
I don't need very long to go through policy 28A, and then I was going to make a couple of comments on policy 32, and then I was done and ready for questions.
Okay, and there will be a few questions, I think, won't there? Might be a couple. One or two, maybe, that's okay.
I'm quite comfortable to let Mr. Gardine...
I don't know, any thoughts on that,
I
Ms.
don't have any concerns about interrupting.
No. Now would be the time to do that. I'm just mindful of timetabling, and you've come a long way to come and speak to us, but as many others have as well, I might add. Okay, well, we can do that if that's acceptable to you. Perhaps we'll do it. I don't like disrupting presentations.
No trouble at all.
Thank you, thank you. So, Mr. Guidine, your opportunity, and I'll ask you to come and sit in front of a microphone, please. And we'll just wait and see if Mr. Stringer turns up, or you haven't heard whether he's having any problems accessing? No? Okay. Just before you do start, Mr. Gardine, the gentleman at the back there has been sitting patiently all day. Are you expecting to submit and make a present?
I'm a director of Waikaka.
Okay, thank you. Thank you. Just wanted to clarify whether you were expecting to sit with us. Thank you. And the gentleman sitting with a peak cap on, are you? I'm an observer with that as well. Okay, well, it's worth just clarifying that. Thank you. So we're in your hands, Mr. Gardine.
Yeah, I'm a local. I will benefit from this mine as part of one of the landholders. I have my submission that you've probably read. And I just want to point out a few things. It's probably, a lot of it is about the people, and the environment. And we will benefit, a lot of the district will benefit, and a lot of the local community will definitely benefit. And Waikaka's seen this in the past. In the early 1900s, the farmers probably had low prices before the wool boom in 1935, and the dredgers went through. They picked up jobs. They delivered coal, they did work on the dredges, and then they did tried to smooth the ground again afterwards and level it out and make some sort of farming out of it. We picked up a farm we farmed close to it in 1981 when I started farming after going to Lincoln, and working at the home farm at Chatton. And I then picked up the neighbouring farm, which includes the river, in 1987. At that stage, the dredges had been through, and then there was a period when the farmers sort of just left it grow sort of rough grasses, and then the catchment board came through and straightened the channel and the period, and tried to make the river more flowable, and ponding and flooding issues were straightened out. And we took it over after that, and the river had gone a bit wild, to say the least. We had took it over off a farmer who had cultivated all the land on the tailings and tried to do a bit of levelling out. And we were losing 2 to 3 metres every fresh on the river, on the bends and on the corners and the straights. So we had to do something about it. So we approached the catchment board, the Environment Southland, and we put willow stitching in on all the corners that we could, and we gathered up any willow we could find in the valley and towed it up, and they placed it in by with a digger and used about the mine. And I think we probably should have had more meetings, but most of the public were in favour. There was some against, and I think that has been dealt with, but if there is still problems, I dare say the mine people will negotiate and sort the problems out. We do also have water schemes in the area. So you talk about bore water. When the mine, L&M mine, went through, and the 20 years plus ago, they drilled a lot of holes and got a lot of artesian water, and we tried to grab some of that for putting pipes down, and the trouble was there was artesian water for a few years and then it just ran dry because it's sort of like small captive patches of water that don't sort of last long, and it's quite orangey water, very orange, and that's very expensive to treat. So on one side of the river, which is the east side, we have the Glenkennick Water Scheme, which is looked after by the Clutha District Council, and then on the other side of the river, the Atama Water Scheme supplies farmers, and it's become a private scheme, and it's run very well. I am a director, so I'm a director on both. And those schemes are quite capable when they're right up to drinking water standards, or will be in the future. So basically, people wanting water can get water. It will be a cost, but I dare say they would be helped out if they're relying on bore water at the moment. Yeah. That's probably all I can say at the moment, but I have had a person on my farm I sold a house to was a bulldozer driver at the Waikaka mine, so I was quizzing him a lot, and I was probably got a fellow councillor that was an accountant there, and I've quizzed them a lot. And I think there's some pretty good will with the mine at Waikaka and the locals. So I'd like to see that would be mirrored in Waikaka. Thank you.
Thank you. Mr. Godine. Question?
Not a question, but I just wanted to thank you, especially the information provided around the historic straightening. That is incredibly useful context. And I remember the freeze in '96 and going ice skating on my grandfather's duck pond at Winton. So, yeah, thank you.
I have a couple, actually, of questions. So the river straightening that you saw, and you said it went wild, and then you added some benefits to that with the willows. But over that time, did the river actually improve kind of as an ecosystem, or did you see it, not get worse?
Through those periods, there's a lot of gravel extraction from farmers helping themselves, because there's no rules really those days. And farmers were most of the owners would try and get the gravel removed on the inside of the bend and trying to keep the bed away from the bank. And it deepened the channel quite considerably, because the channel was very shallow and very prone to flooding. And if you look at the bridge, the main road bridge, if you climb underneath there, you'll see the base piles go down and then the base concrete, and then you see the leg piles are visible below that now. So it's probably dropped a good metre as it's worked its way up the river. And I think, well, I used to go fishing in the dam, they called it, which was when I was a kid, and that was at the bottom end of the mine where the wooden bridge is. And there used to be a huge pond in there, and you'd fish in there, and it was quite good fishing. But it's always been good fishing, even with the river moving.
Leaving a lake there has other potential opportunities, such as inland agriculture, inland water sports. You just have to look in other areas of the country where there's large bodies of water. There are houses and housing developments spring up around them. So there's one opportunity there is putting housing around it, putting parks and recreation, walking tracks, boating facilities. So yeah, it's not just, you're not just wanting to fill back in a hole at the end of the day. My other part of my submission is I'm ambivalent about what you plant on the side of the river. It doesn't worry me whether it's native. So I just am mindful now towards the crack willow, having crack willow at the back of my farm on the Waikaka stream. It is a pest and can be quite invasive in places, but it does do a very good job at restricting the river to its watercourse. Other than that, those are the main ones I'd just like to touch on for you to take consideration on. And any questions out of that is far away.
Does there any further questions sort of come up from that? No, I don't think so. You mentioned crack willow, and we've been having some conversations about that. Do you know an alternative that would be equally beneficial but less problematic?
Look, we've used the short shrubby willow from east before, so this would be going back to when my father had the farm, where we were doing some work under the direction of ES, and we were given poplar willow wands by them of about 4 or 5 different species of shrub willow. We recently, within the past couple of years, had an ES fella on the farm. He said, oh, they're a pest species now. So I don't know, like the shrub ones do really restrict the water flow in floods and seem to accumulate a lot more debris, forcing it out around the willows and into the farmland a bit more. That's just my personal observation. They do seem to accumulate a lot more, they accumulate a lot more trash and debris build up and behind them. I couldn't tell you, like, we have very little native planting on our farm, so I couldn't tell you what the flood, how susceptible they are to holding of floods and how they manage the flood waters. I couldn't tell you, sorry. Only very few large flaxes around rivers and toys. But yeah, toys and sometimes the flaxes come with other issues such as rats and ferrets and stoats living in them. You get a higher pest population. The crack willow does its job, but once again, as John previously said, that it does spread, it just breaks off and it'll grow from anything. I know from where farmers have cleared the willow, and we've also cleared the crack willow in places, a couple of years, that's the way I'm growing again.
Okay, thank you, Mr. Stringer. I don't think we have any more questions for you, so thank you for your presentation.
Yep.
And I guess have a good rest of the day. Thank you.
All right, yeah, thank you. Sorry I couldn't be there in person.
No, thank you. That's all very good.
Cheers.
That's all I had on 28A. I wonder if the panel might have any questions on that matter.
No questions there?
I think that's quite clear, thank you.
Okay. I also had a couple of notes on policy 32, given that was the other main policy in contention. So my position in my evidence is that the relevant provision of policy 32, I might just read out the policy actually for ease of reference. So it says to protect significant Indigenous vegetation and significant habitats of Indigenous fauna and maintain Indigenous biodiversity associated with natural wetlands, lakes and rivers and their margins. I don't consider that this is a situation where we have significant Indigenous vegetation or significant habitats of Indigenous fauna. We don't have any evidence from ecologists to state that that is the case. I've gone and done a bit more reading on this because I noticed that there's no plan definitions of what that significant vegetation and habitats of Indigenous fauna might be. However, the regional policy statement does provide guidance on that in the biodiversity chapter. So we could ask for ecological evidence on whether those criteria are met. However, having reviewed the biodiversity chapter and the criteria for significance, I noticed that in relation to rivers, that this type of habitat is not in the list of habitats that would typically be fit into those criteria. So, for example, there are braided river habitats in the biodiversity chapter and the relevant appendice, but not these lowland hardbed river types. So the way I apply policy 32 to this proposal is that that second part of the policy is relevant. So maintain Indigenous biodiversity associated with natural wetlands, lakes, rivers and margins. This again means that we're not trying to apply policy 32 to ditches and ponds. That's relevant to the rivers, Shepherd's Creek and Waikaka stream. And that's the basis for the assessment in my evidence, and I just thought I'd explain how I got to that.
Thank you. Question on that? No? Yes, there is one on that.
Thank you. Are you also moving on to policy bio.9, biodiversity, and, bio 4, maintain Indigenous biodiversity?
I haven't prepared any notes on that, but I can refer back to my evidence and answer specific questions.
I was just interested in whether you had any revisions to your interpretation of this one as well, given your change in opinion with regard to the other key policies.
I'm sorry, just having a quick reread of the assessment. Yes, I'm happy to stand by the assessment in my evidence on bio 4, and I think that's on the basis of appropriate conditions to achieve the rehabilitation objectives.
Thank you. And so this policy reads, manage a full range of Indigenous habitats and ecosystems to achieve a healthy functioning state. So
for like or same for same?
Yes, correct.
Yes, thank you, yes. So I just wanted to make that quite clear because some of the submitters have seen that a little differently in how they've interpreted that, but thank you. We good? I want to follow up, yeah, thank you.
I just had one question regarding the letter from Hokonui Runaka, which indicated that some of their concerns had been addressed through changes to proposed conditions. And I was just wondering if you could clarify what those changes were.
That's the changes in proposed conditions from the application to the evidence. So we had a lot of discussions with Hokonui Runanga about the proposal and the various mitigation measures, and the conditions attached to my evidence were the ones reviewed immediately before that letter came back. I personally have an email from Hokanui Runanga saying we're happy with these.
If possible, would it be possible to get a track change that evidences that?
From the application to the evidence version? I can do that. Would the panel like me to focus on the next revision of conditions or providing that track change version?
Just clarifying what we're looking for.
The correspondence from the Runaka, does that clearly state which version they're comfortable with? Because that would be handy for us to see. If you were able to share that email correspondence and if there's a clear link between the evidence version, then that would be useful.
I'm just looking at the email now. What I have is an email on Thursday, 20th of November, with me sending the updated conditions to the Runaka, and then an email back from the Runaka on the 21st of November saying that they've completed a detailed review of the conditions and we're comfortable with how it all looks.
That would be handy to receive a copy of that for the record.
I'm comfortable to provide that.
Thank you.
Thank you. Just finding a way. We're ready when you are. Oh, sorry.
No, I'm ready to take questions from the panel.
Okay. Here we go.
Thank you, Ms. Colley. I do have a couple of questions that I would like to check, I guess, what the current status is. The first issue is the Gore District Council legal road corridor and the prospect of having planting in the berm area. So I'm aware that the landscape experts have agreed in terms of whether that can be provided or not in terms of their assessment, but I am interested in what is the